how it works. It is on. It is on. Okay.
Especially when we get the basket.
Right on time. It's quiet
It's freezing in
here.
here.
Drop.
This is the mail room. It's cold in here.
You really are? This feels great today, I'll tell you. This is wonderful. My glasses on here, so get my life together here for a second. I'm ready to go. You guys all ready to go this morning?
We're ready.
You're ready. Okay, that's great. Well, thank you for coming this morning. I'm Tom Rice, and I'm a representative here who chairs the committee for the study of the shared parenting issue. And that's what if you're in here for any other reason, if you're in here for tax reform or anything like that, you're in the wrong place. Okay, this is not the trauma care study committee either. How many we got? We got 20 study committees, I guess. But as probably some of you old hands in this know, we do a lot of study committees in the off season and attempt to get some facts together by which we make judgments in terms of legislation or potential legislation next year. This is the first of 3 meetings. The way we've kind of considered these meetings is that those who have testimony that represents either an overview or a level setting of the issue of shared parenting, the custody issues, and those who have a pro view of why shared parenting should be something the legislature ought to take a more aggressive stance on, is scheduled for today. The second meeting, which will take place Tuesday of next week, is for the con side, and those people who would oppose any change to the current law or some change in another direction that's more restrictive on that basis. And then the third meeting, which is the 26th of October, will be when we'll pick up all the loose ends and try and tie it together and to take any testimony that we feel we need at that point in time and to discuss the possible alternatives in terms of where we go from here. So that's what's going on today. We're scheduled to be here from 10 to 1. The witness list is about 10 people long. If we have time, depending on how things go, we'll take a check midway through and see how we're doing, and if there appears to be an opportunity to get it done a little bit earlier, then we'll probably pass around a sign-up sheet for anybody else who wants to speak. I will tell you that we are being webcast today. That little red light on that camera up in the ceiling back there means that you can claim to have worldwide venue today. That's great, isn't that great? To anybody who wants to tune in, I mean, they could be any place, and they could be sitting in Tehran or Iran today and listen to this. That'd be interesting to see what the women there would think of this proceeding. But in any event, so I'd ask you, those who are going to give testimony, I'd ask you to come to the microphone. And if for some reason there's some interplay between the committee and you, we'd ask you to make comments from the microphone, and I'll just stop you and ask you to come up if in fact we're not getting it, because we want to make sure it's recorded. Also, if we did request for those who have already signed up that if you have written testimony, that you bring it forward, or that you get written testimony to the committee afterwards. One additional advantage of being on the webcast today is that this program will be available in the archives, and you can get that by
Going to the main website.
And the main website is
www.legis.state.ga.us.
Got that? No, probably not. www.legis.state.ga.us.com. Okay? We make this hard purposely, But actually, it's a good way for you to review what's happened here, and for others who are seeking to give testimony to review and potentially rebut, and so on and so forth, as we go forward. Okay. Mr. Keith Williams here is our House Research legislative aide. He's actually the aide to Chairman of the Rules Committee here today, and he is serving as the guy who puts all the stuff together for us to consider, and provides us some of his intellectual insight at the same time. And so if you have written testimony, you need to get it to him. Without further ado, let me introduce the members of the group here. That reminds me, if you got a cell phone, it'd be really good to do what I'm going to do right now and turn it off. And so if we all could just take a moment to do that. All right. The first one is Mark Butler, but Mark's on his way. He's detained in traffic. Mark is the Vice Chairman of the State Institution and Property Committee, and is an important member of this group, as are every one of us. Earl Earhart is Chairman of the House Rules Committee. He sits right over here, and has been a long-time member of the House, and is well familiar with this issue. Edward Lindsay, down here to my right, is Vice Chairman of the House Judiciary Committee, and practicing attorney, and has got some great insights in this area, and we appreciate the fact that you're here along with all the rest. And Judy Manning is our erstwhile chairman of the Children and Youth Committee, which has a lot of oversight about the very people that we're talking about in this issue. I chair the House Motor Vehicles Committee, which you may think is, why would somebody who chairs the Motor Vehicles Committee be in this meeting? You know, that's the wonderful thing about the legislature. Anybody in this legislature can claim some expertise in some area that they're not responsible for, and therefore offer legislation on it. We have, I was going to say Jill Travis, but we don't have Jill. Okay, all right, Legislative Counsel. And you've met Keith already. Where's Mary? There she is. She's behind the post over there. Hi, Mary. This is Mary Lewis back here, and she is now your...
She's a former staff in the Rules Committee office, but now a law student at Georgia State.
Law student at Georgia State.
Service staff of the committee also.
Well, that's wonderful. We need all the help we can possibly get. Now, let me name all the people on this committee that are attorneys. There's Edward Lindsay, Edward Lindsay, Edward Lindsay, and that's it. Edward Lindsay is the only attorney, except for Keith, who is an attorney in waiting for his results of his bar exam. So I guess, isn't that right? Is that right? Yeah. And so we've got a lot of talent here today. But the point I'm trying to make to you is, for the attorneys, particularly the attorneys who are going to present today, there are people here who don't speak the language as fluently as some others. So, be patient with us, and just consider the questions you get, and try and give a full answer to each one of them. Let me just start off by saying that I'm going to tell you straight out how I come to this. I had a group of fathers in my district who got together and invited me to a breakfast. Had about 10 of them there. And they told me of their stories individually, anecdotally, of their experience going through the divorce process and the custody issues with their children. Out of that, I gained an interest in trying to be responsive to this issue, and started doing some investigation of it. And as I went forward with it and investigated further, looked at some of the data, began to understand that that this issue is a really, really difficult one, and it's not something you just throw legislation up on the wall without an awful lot of consideration in terms of why you might be doing that. Some statistics that might be of interest as to why we're here today, and this comes from the Kids Count database. 31% of all U.S. children as of 2004, which is the latest statistic there, are in single-parent households. Another HHR statistic, Health and Human Resources, says that there are more than a quarter of American children, nearly 17 million, do not live with their fathers. Girls without fathers in their life are 2.5 times as likely to get pregnant, 53% more likely to commit suicide. Boys without a father in life are 63% more likely to run away, 37% more likely to abuse drugs. Both girls and boys are twice as likely to drop out of high school, twice as likely to end up in jail, and nearly 4 times as likely to need help emotionally or for help or emotional behavioral problems. And that's from the HSS press release probably about 6 years ago at this point in time. So those types of statistics lead us to a concern about the issue, and that's why we're here today. I wanted to frame the issue. We are using, and some of you have. Okay, there's 2 stacks on the back row. This is a list of the considerations for shared parenting law. Now, what this is a compilation of different issues that we believe the committee should look into and potentially address. It does not mean that there are a preset number of things that we're going to introduce into law by way of legislation next year. These are things that we want our witnesses to comment on and to help us understand a little bit better in terms of those things that would impact the law and make this whole situation of shared parenting a more adaptive thing to what we're attempting to do in this state. Those things I see some people passing them around. You must have picked them up off the back, and if you don't have one, you might want to get one. All the witnesses have one? All the witnesses have one. Okay. Well, without further ado, what I wanted to do is to give each one of our committee members a chance just to comment on their objectives for why they're here, and to let you hear their voices so it won't come out of the blue to you. And we'll start with Representative Earhart, the Chairman of the Rules Committee.
Thank you, Chairman Rice, and I appreciate the opportunity to participate in this study committee. One of the things that we're beginning to do in family law in Georgia is, for the first time in probably 20 years, take a look at some of the things that we haven't dealt with in that interim. As most of you probably know, we changed the support laws in a significant way over the last 2 years. It was 20 years before we even took a serious look at those, since the 1989 session. Custody falls pretty much in the same arena. My personal philosophical opinion is that any issue needs to be looked at seriously by this legislative body. When we have a body of law that hasn't changed with the time, then at least we should study it at the very least. I think there are going to be some suggestions from many different perspectives over the next 3 committee hearings. Looking forward to hearing all of those different perspectives on many parts of our family law. Everything from shared parenting to 14-year-old election to custody arbitration to just about anything that affects custody, the direct appeal. I know Representative Lindsay and I have had a long history with that particular part of the issue. But with that, I'll leave it to that and look forward to the testimony. Thank you, Chair.
Thank you, Representative Earhart. Representative Manning, Chairman of Children and Youth.
Good morning, and thank you for coming. I really appreciate your willingness to be here, as well as the chairman for bringing this issue to all of us. As a mother and a grandmother and a wife, and I've thought about divorce on numerous occasions. Haven't done it yet, but nonetheless, I have thought about it, and I've often queried as to how I would react if I were put in that kind of situation. I'm for kids, all kids, male, female. All children are my emphasis, as well as being chairman of Children and Youth. I think that I bring to the table a different kind of view than the rest of these guys up here. And I hope that we'll all come out of this with a better understanding of what it is to have custody of a child and to care for that child and nurturing that child so that they will become a well-rounded adult. And I appreciate your willingness to come and to listen And I hope that if there's anything that I personally can be of service to you, you'll feel free to get in touch with me. Thank you.
Thank you, Representative May. Representative Edward Lindsay is Vice Chairman of the Judiciary.
Thank you, Mr. Chairman. I also applaud you for bringing this before us so that we can discuss these matters before they get to the committee setting during the General Assembly session. As all of us know, 40 days and 40 nights is off a short time period to mull over the seriousness of laws, and as the Vice Chairman of the Judiciary Committee, which would handle a bill such as this, advance notice and advance study of any kind of issue, I think is greatly beneficial. There are certain things that I want to see us take a look at as well from my vantage point, both in terms of a lawyer in general and also my community service work over the last 13, 14 years has been that of a guardian ad litem in the Fulton Superior Court, so I've seen a good number of these custody battles fought out in the courts. Basically, what I'm looking for is anything that will increase the transparency of the process for the parties, so that there is not only an actual fairness, but a perceived fairness by both parties as they go through the process, and anything that will enhance the best interest of the child. That's what I believe sort of needs to be the bedrock of any of our considerations of any bill, what will advance the best interest of the child as they have to go through a very painful process in a divorce case where there's a custody fight. There are certain specifics that we've discussed and that I do believe that we need to take a look at. One, of course, deals with the collaborative law, as we've discussed in the past, also expanded use of arbitration. I want us to take another look at the 14-year-old rule in terms of election process. I believe that we also need to take a look at some of the penalties that may be imposed when one parent or the other abuses the process, what we can do to put an end to some of the abuse that we're seeing in the courts. Take a look at the presumption of shared custody and how we can codify that while still maintaining at a bedrock the judge's ultimate decision regarding the best interest of the child, making sure that the judge issues a written order explaining his reasoning for his decisions so that both parties can understand that, and also take a look at how we can get a greater overview of certain cases from the appellate courts. We considered direct appeal on the child support provisions. We ended up with an agreement with the Supreme Court to expand their number of cases that they accept, and we need to come up with another process here, hopefully, that will also open up the appellate courts to greater review of some of these decisions from the trial courts, so that in the case of abuse by a trial judge, that a party has a remedy. Thank you, Mr. Chairman.
Thank you, Mr. Lindsay. Appreciate it. Well, Mr. Mark Butler has joined us as Vice Chairman of the State Institution of Property. And Mark, welcome. You have some comments.
Yeah, I guess my number one reason for being here and showing interest is in divorce cases, we tend to focus on the parents, the husband and the wife, and they tend to focus on themselves a good bit too, that I've noticed. And we tend to forget that it's not just about two people; it's about the whole family and the effect that it has on the whole family. And that's probably my biggest interest is in the study committee. I believe this is a subject matter that has long been kind of put on the back shelf, maybe just because of the fact that it may not be as some people may say, a real sexy issue, so to say, because the fact that it's not one of those things that just pulls a whole lot of folks in for votes, but it does have an extreme human factor to it, and the fact that this affects so many lives. And I would like to see us come up with a way of making sure that the children are the number one consideration in a divorce when they are there. Because the things that happen in divorce, the things that happen to children in divorce, can have long-term effects down the road. And if we can come up with a way to make this easier on children, and hopefully keep both parents involved in that child's life from here on out one way or another, then I think we'll achieve a lot going down the road.
Thank you, Mr. Butler. Appreciate your being here today, and appreciate all of you being here today. I think we're ready to get started, and our first witness today will be Judge Billy Ray. And Judge Ray is a member of the Superior Court in the Gwinnett Circuit. former Senator Ray, I should say, too.
All right, good morning. Thank you, Mr. Chairman. Let me make a couple of quick statements unrelated to substance, and that is, one, as I often, in a role as chairman of the Legislative Committee for the Superior Court Judges, come before the General Assembly on bills where I am presenting the position that the council as a whole has adopted, or either for or against a bill, usually involving procedural issues involving the General Assembly, and this one are procedural issues involving the courts that are under consideration by the General Assembly. And this bill or idea of a bill might fit that parameters to some degree. Although I'm not here today on behalf of the Council of Superior Court Judges, we have not taken any position. There is no bill. We don't usually meet on things until there is an actual proposal. So the comments I share with you today are really just my personal feelings, both as a trial lawyer who has had about 14 years experience trying domestic cases, divorce cases, custody cases, as well as 5 years as a Superior Court judge now in Gwinnett County. So they're really personal to me. The first thing I think that I would talk about is the issue of what the current law is, as I understand it, sitting on the bench trying these cases, and that is that joint physical custody statutorily is stated that it is a consideration that we may take. In other words, in any particular case, we may consider whether or not the parents should have joint physical custody. Now, custody often is defined both as legal and physical, with legal custody being who makes the decisions, who is the guardian per se, decides where the children go to school, whether they have surgery, later in life, how old are they when they date, even decisions like that. Whereas physical custody is defined in Georgia law as being where does the child or children substantially spend their time. And so when you talk about custody or non-custody, you're talking about all of that. If you're talking about physical custody, you're just talking about really where the child or children are going to be. Case law is a little bit stronger than the statutory law. What case law says, it tells us that in all cases we may not just consider joint custody, but that we shall consider it. We are to look at it to determine whether or not in every case that comes before us, whether joint physical custody is something that should work. Now, many people would have, I guess, differing opinions on whether that occurs in every case. And I would say that I think it probably depends on where you are, who the parties are, and who the judge is. Certainly a case can be made that younger judges, perhaps judges of my generation or a little older, a little younger, who have grown up in an era where fathers, for example, taking the traditional situation, have taken a more active role in their children's lives, maybe are more easily or readily able and willing to consider whether joint custody is something that is in the best interest of the children. And indeed, that is the ultimate yardstick by which we have to make our decision, is what is in the best interest of the children. But the key is whether or not, in all cases, it is fairly considered, not just by the judges, but by the parties. Because I'm here to tell you that many times parties will come into court and it is a de facto assumption on their part that the judges are not willing to consider joint custody, that is not something that they really need to talk about, and that you should just go ahead and assume in the traditional sense that mom is the one that should have custody. I do think that lawyers develop an understanding of who their judge is. They call and ask about their judge. Many of them practice in front of the judges. They know what judges are more likely and apt to consider joint custody situations, and those that perhaps are more traditional in the sense that they are not going to give a whole lot of consideration to that. One issue that I wanted to touch on as well is let me start with this. There is this proposal, for example, that in all cases that there be a presumption of joint custody. That's not necessarily new. In the General Assembly about 6-7 years ago, a bill passed out of the State Senate that in fact mandated, it said that joint custody was the presumption, that it could be overridden by the best interest of the child, but that is the place where you start in talking about the issue in any particular case. It didn't get a hearing in the House that year, and it died. What that bill also provided much like some of the ideas that are going to be put to you, is that the parties have to come up with a parenting plan. I think former Senator Tanksley, that was his idea, that he wanted both the father and the mother to write a parenting plan and submit it to the judge. And then when the judge made the ultimate decision as to whether it was joint custody or not, that the judge would incorporate that parenting plan or could make changes to the parenting plan based on what he or she thought was in the best interest of the child. From my personal perspective, I think that's a good thing. I often tell, on both issues, both as the presumption and as to the parenting plan. What does the presumption effectively mean to the judge? Well, it doesn't really mean anything as a matter of law, because the judge, if he or she believes it is in the best interest of the child, that they live primarily with the mom or primarily with the dad, then the judge gets to make that decision. And even though I haven't polled judges on this issue, I can assure you, as is their normal cases, they want maximum discretion and they want the ability to decide what is in the best interest of the kids based on the facts as they are presented. Does that mean that there shouldn't be a presumption one way or the other? Well, there is going to be a presumption one way or the other, whether you define it in law or not. From one judge's perspective, it may be a presumption for mom. For another, it may be a presumption for dad. That would be rare. But in many cases, I think now, there may be a presumption of joint custody. So there's going to be a presumption whether you define it or not. So there may be those who would want to throw darts at that proposal and say you shouldn't have a presumption. But if the judges have the ultimate ability to make the decision that is in the best interest of the child, the presumption really should not be something that should be a sticking point for anyone. Now, there's also the proposal that presumption should not be overridden unless you find that one parent is unfit. I'm here to tell you that I don't think that's a good idea. Intellectually, I cannot say that I have had a great number of cases come before me where I would find one parent was unfit. There have been some, and there are those cases. Depending on where you practice law or where you sit as a judge, there may be a lot more cases. If you sit in the inner city where drug use is very common versus maybe a more rural area where it doesn't rear its head quite as much, then maybe you have more cases of unfitness. But absent something like drug abuse, physical abuse, extreme verbal abuse, you're not going to find many judges that are going to find any parent unfit. Now, if you go with a proposal and you say that, well, if they're not unfit, then you have to have joint custody, I don't think that in all cases you're going to be doing what's in the child's best interest. We look at our lives, we look at the lives of many people that we know, and many parents have arranged their lives in such a way where one parent has significant, substantial, predominant care and responsibility for the children. You may have a situation where a parent travels 80% of their time. That's certainly not uncommon in our mobile world. And would it be in the best interest of the child in that case to say, and we'll just say it was mom that travels 80% of the time. I had that personal case as a lawyer one time. Would it have been in the best interest of those children to say, well, mom's going to get the children 50% of the time, even though Monday through Friday, every week of the year, she's going to be out of town? I don't think that would be in their best interest. You would have daycare issues. Mom's never there at night. She's never there in the morning. And how would it be better for those children to be staying with surrogates for mom rather than being with their dad, who worked local, lived local, and could be there when the kids were off the bus and could be there at all their activities? So I don't think personally that we should get away and say, okay, we're going to have that presumption. It's hard and fast, and unless you find a parent unfit, you should do away with what ultimately I think most people would find would be in their best interest. Now, if you go with a presumption of joint custody, then there are certainly ways that I think most judges would find that you would override that presumption. If you have parents that just do not get along, they can't exchange the kids in a civil way, to the point where you almost have to go to the police station, something that I hate to see. I've never personally ordered, but I have seen parties agree to it, where they want to exchange the kids at the police station. How can those parents really effectively parent together if they can't get along in such a way to the point where they have to go to a police station? If the distance of the residences of the two parents is so substantial that they can't freely transfer the kids back and forth to school and even just amongst themselves, And that may be even within the county. Gwinnett County, where I live, has over, I think, about 800,000 folks now. If you're more than a couple of school districts away, I mean, you might as well be Atlanta in Gwinnett County just because of the traffic problem. Would it be in the best interest of the kids in that scenario? Maybe not. It really just depends on all the factors. If the relationship of the parent and the child at the time of the divorce or subsequent to the divorce was so poor, even if the parent was a fit person, and even if perhaps that parent didn't become estranged from their child on their own behalf, would it necessarily be in the best interest of the children that you have joint custody and that parent is certainly fit? And I've talked about the historical situation. Maybe the one parent travels so much. So I personally don't think that you want to set a bar that says that a child has to live with a parent equal amount of time unless unfitness is the standard. But I do think the parenting plan is a good idea, and I think personally, I have no problem, and I don't think many judges would have a problem with saying that if you adopt a presumption of joint custody and the judge is going to deviate from that presumption, that you make the judge put it in writing. If you have a procedure where these issues get appealed more readily, you need to have that issue in writing or on the record in some way for the appellate court to know why did the judge make that decision. And I would say this, that when I went through judges school, one of the things that I was taught about parental cases is that in most cases, make your decision and announce it from the bench and to explain the reasons on the record to the parties so that they understand why you made your decision. Now, that doesn't mean that the party who doesn't prevail is going to like it or agree with it or even like you because you told them, but at least you've given them the basis for why your decision is made. And as judges, I don't think we should be afraid of telling folks why we rule in a certain way. And if we make a bad decision, and I'm not going to stand before you and tell you that I haven't been reversed on a decision because it's just sort of the nature of the game of being a judge. We shouldn't be afraid that that's going to occur, and we would want the right decision to be made. And if our superiors, the appellate courts, Court of Appeals, if the law allowed that, or the Supreme Court felt like we were wrong, then so be it. But I don't think we should have a problem with that. I wanted to quickly address the issue of the age of election. If there's anything that Superior Court judges around the state would agree on, uniformly with probably no dissent, it is that we don't particularly like the law about the age of election at 14 deciding where you want to live. Now, we follow the law. It is the law. Cases come to me all the time where a 14-year-old is electing to change homes where they live. And in many of those cases, it's not a problem. Maybe mom's raised a child and the son wants to go live with dad. And in many cases, that's not a problem. And the vice versa has occurred. But there are those cases that we see where kids basically are using their parents and the ability to live with one or the other as leverage for no restrictions, no rules, cars, material items. And they go back and forth. I've had one particular case that a child during the term of his minor years went back and forth 5 and 6 times. I really felt sorry for the parents. There was no way they could effectively manage that child, because if any one parent tried to discipline that child, he would bolt and go live with the other one. And now I'm not sure what's happened long term to that child. I haven't been able to follow that. But we know that the seeds of a lack of responsibility and commitment long term were planted in that child. I wouldn't be surprised if he himself gets a divorce at a young age, because he see and saw that change and just moving back and forth with a lack of follow through was possible. I think many parents would support that. Before a divorce decision is ever made and you don't know where the child is going to live, if you took a poll, I would bet you most parents would agree that it's not in the best interest. And in fact, I ask a lot of them that similar type question, and they don't want to split up kids normally. They don't want kids being bounced back and forth. I know historically where that rule came from, at least my understanding it came from, and it was developed at a time perhaps where the mom always got custody and dad never got custody, and we did have that time in our existence where that was sort of the institutional prejudice that existed. But that's not the case anymore, and kids need some ability to rely upon a parent to be a disciplinarian. So we would uniformly support, I think, getting rid of that. The idea of arbitration is an interesting idea. Right now, it's not supported in the law because the case law says is that the Superior Court judge has to make the final decision. Even if parents come to us with a settlement agreement that says that we're going to have joint custody and we're going to try to decide all these issues, and if we can't agree, then we're going to go to our neighbor, who we both trust and love, to make this decision for us. I have to reject that agreement as to that point because the law says that I have to be the ultimate arbitrator of everything relating to custody. Superior Court judges, I think, would be very welcome to say that if the parties who best know their situation can agree to arbitrate their matter and can agree to pick an arbitrator who they trust and love and believe will make the best decision, then why should I come in and hear the same evidence that that person has without any of the personal history, perhaps, that arbitrator have, and have to either agree with that arbitrator's decision or potentially override that arbitrator's decision. And we use this in law uniformly. You can arbitrate anything. And so long as the rules are known in advance before the arbitrator has reached their decision, both parties should be required to live by that decision. And you could use the same basis in law that you currently have, where the judge would have limited oversight and could only overturn the decision of the arbitrator in cases of fraud, manifest abuse of the law, and there's one other ground that I can't currently recall. It would still give us the right to override an arbitrator if that arbitrator basically says, well, I agree she's better, but I'm going to side with Daddy on this. Or if you can prove that there's some kind of collusion that was going on. But I think the arbitration idea is a very interesting idea. And the final point that I would address in some of the proposals I've seen is the final two, really, is the issue of sanctioning for withholding a child and relocation, how that should work. The issue of relocation is in a better state today than it was about 18 months ago. Formerly, the law was that one parent who had custody could pick up and move to another state, could move across the country, and that in and of itself was not a ground that would allow there to be a material change in circumstances and a custody hearing to even be held. You would have to have something more than that. And that didn't make intuitive sense to the Superior Court judges. Clearly, when you pick up a child and move it across the country, or even perhaps moving it 5 counties over from where you currently exist, it's going to change the balance of things. And we ought to be able to at least look at it to determine that if it's in the best interest of the child that you maintain the current status quo. The Supreme Court did issue an opinion a few months ago, really over a year ago, where they have recognized that fact finally. And so, and under the current law, if a parent were to pick up and to move in such a way, in a long distance or even a short distance that is long by virtue of the environmental considerations of traffic and such, a judge can take a look at it and change custody if he or she believes it's in the best interest of the child. Whether you want to have a presumption or not relative to that, I'm not sure. I think that's an issue of policy for you to decide. But at least now that issue can go back before the judge to take a look at. The issue of do you sanction when a parent withholds a child? Right now, it really depends on the judge what happens in that regard. We all have our policies. My policy that, of course, I will deviate from in appropriate circumstances is that if I find that a parent has intentionally withheld visitation to a child from the other parent, is I generally award the other parent who lost visitation 3 times what they lost. And when I've done that in cases, I don't ever have a problem with that parent ever again withholding visitation. There is a lot of research out there now from psychologists on this issue that would state that judges really should not use incremental baby steps when they find that a parent is alienating a child, withholding visitation repeatedly, intentionally coaching a child to disassociate himself from his father or his mother, and that we should just go ahead and make changes of custody. I have not done that yet in a case, but after I have watched much abuse in many cases over the years, I'm given some serious consideration of doing that sooner rather than later because of the fact that we've got these children for a limited number of years, and if we don't take quick action, suddenly a parent will become estranged from a child in such a way that you can never really repair that damage. So that concludes the comments that I have to make on this point. I do want to say this final point is that I was raised by a single mom. My dad was not really in the picture. He died when I was 13, and he, before that, had an alcohol problem. my mother is my hero. She worked as a secretary for Workmen's Wages and made all my ball games and all my school events. I don't come at this from a prejudice for being pro-father or pro-mother because I recognize the important role she had. That being said, I am very much in favor of having substantial access for a father and a mother to a child in a divorce situation when it is in the best interest of the child that we do so.
Well, thank you, Judge Ray. Questions from the committee? Representative Earhart.
Two quick questions. That was an excellent presentation, Judge Ray. With respect to the case law that you mentioned on the joint physical custody, I don't want to put you on the spot, but would you provide that site to
Yeah, I'll be glad to.
council when you have it so
I
that we
will.
can take a look at that? And following up on that, what is the are you saying that basically the distinction is the written finding of fact between what we have now, the requirements that are in the current statute, and what would necessarily be anticipated in a shared parenting statute, that the judge would then be required to have a finding of fact in those particular cases? Is that the...
Well, yeah, I think it kind of follows the proposal in the new child support law where there is the table and we will mathematically find ourselves to a number, and then we got the ability to raise or lower that number or even change the payor and the payee, but we've got to give reasons why. And if we state those reasons, then, of course, it will give the parents an understanding of why we did it, and will give the appellate courts a reason to know if they do take the case on
I
appeal.
would think that was something as important as this, that'd be a reasonable requirement to at least
Yeah, it
state
would have to
reasons.
be within reason. I think the appellate courts would take a look at it and they'll say, well, the trial judge is the trier of the credibility, because the stories are often, I mean, divorce cases, you know, there's always somebody
That's
lying.
not the basis for
Yeah.
the appeal. The basis,
Right, and so if the judge makes a finding, he or she's going to have to make a finding about what they found the facts to be, and then based on those facts, this is why I'm making this decision, and give the logical connection to the facts in the decision.
Second question, this goes back to the 14-year-old election. We've dealt with this over the years. This is one area of the law that we have made some changes. It's not necessarily specific to the overall custody, but one of the changes we did make was the 11 to 14 provisions, where the child at those ages has the capacity to make a presentment to the judge. That's actually
That's right.
a shall. That's a requirement. When you do talk to the Superior Court judges, can you get a sense of whether or not and how that has actually panned out, and whether it's working, maybe from your own personal experience, whether if we do make changes to election law, the election itself, whether that would be the route to continue to take, or something along those lines?
Yeah, I think that's worked well. That happened before. I think I was still in the legislature when that law passed, and in fact, I believe the original bill was maybe going to lower the age of election, and that was sort of the compromise, and the compromise has worked extremely well. And most judges probably did that anyway, but I think it works particularly well. And but there is one complication that occurs because of that, and that is this. If the 14-year-old, let's say you have two kids, you got an 11-year-old and a 14-year-old, the 14-year-old elects to go live with mom, okay? The 11-year-old also living with dad. Well, the fact that the 14-year-old goes to live with mom, that is a material change in circumstances. So now the custody of the 11-year-old is available or to be determined, and the 11-year-old says, you know, he doesn't prefer mom or dad, he just wants to be with his brother. And so suddenly the 14-year-old, and so he tells the judge that. The judge, you know, may very well go along with that, with the desire to keep the kids together. So what you then have, and so I don't have any problem with the 11-year-old saying that. I understand that. I mean, that's a logical thing for the 11-year-old to say. But then you have the 14-year-old electing under the law to go live with mom, or vice versa, and pulling the 11-year-old. So the 14-year-old is not just making a decision for himself that he's probably not old enough to make, but he's also making it for his 11-year-old too. So yeah, I think if a change were made, you should definitely keep the ability of the child to express his opinion or her opinion. And you know, lawyers are creative; they'll come up with reasons that will themselves get the issue back before court. Mom's got custody of the two kids, and they're not getting along, and they're fighting and they're fussing, and the school grades are going down. That gets the issue back before the judge, and then the 14-year-old or 15-year-old can say, "Judge, I want to go live with my dad or my mom, and this is the reason why." And it gives the judge the opportunity to investigate it. And if I could address one more issue, and that was the issue of videotaping conversations with kids. I'm not for that, personally. I will generally not interview kids in the domestic cases with the lawyers present. They usually want to be present. Not usually. Many times they want to be present. I think the fair way to say it is that I'm not interested in talking to them if you're going to be in there. I don't want to put them in the situation. We're not going to bring them in the courtroom. Why are we going to take them into my office and have lawyers hover them on them? I want to be able to tell the kids that they can tell me what they want to tell me. I don't even ask them who they want to live with. I say, I'm here. What do you want to tell me? Has a little bit more lead into it than that. But I don't want the lawyers there, and I want them to feel free to be able to tell me what they want without me having to pull it out of them, without the lawyers being there, and without them being afraid that their parents are going to know what they say. And so I just don't think that's a good idea. Again, it's an issue of policy, I guess, for y'all to decide whether it is or it isn't.
That's all I have.
Other questions from the committee? Let's go to Representative Manning first.
Judge, that was an excellent presentation for somebody that's not a lawyer. It does help to understand exactly what we're talking about here. One question I have is, what happens when the custodial parent, quote unquote, marries or changes something in the family dynamic? Does that case get brought back again for you to look at and perhaps rule on whether that current situation needs to continue, or is there any credibility given to that at all?
So, like, the mom gets custody, but later she gets married.
Yeah.
It won't. That issue.
Or to someone that perhaps has other siblings,
Right.
other children.
Well, what normally would happen is that if that is the issue that brings it back to court, the person she marries maybe doesn't get along with the kids. Or maybe the more typical scenario is mom goes out or dad goes out and gets married to somebody who has a criminal record or a drug problem. And then the other parent is concerned about that, genuinely or not, but concerned about it. And so it comes back to court as a change of circumstances. And so those cases will make them way back to court. But just because you get remarried, you take a typical middle class situation, that doesn't get the issue back before you. If we got the Brady Bunch scenario, we've got 6 kids living with 1 bathroom and bunk beds, it might make its way back because one child or the other is unhappy because things are so cramped in their house or their apartment, and the judge will have to take a look at it in that regard. But that's really a rare case that we see it just because there's been a remarriage. There's something else externally that would have to happen before we give.
So there's no way for the family really to get a reevaluation of the custody points after the judges make the decision.
Not just because of a marriage. I don't think many judges would say that is in and of itself a material change. There's got to be some other environmental reason. The person they married is bad. They want to move them to South Georgia. They have a drug problem, something like that.
Okay, thank you.
But there's just one point. There's not a lot of law on it to tell us. But that's just what I generally see.
Thank you, Representative Manning and Representative Lindsay.
Thank you. Judge Ray, thank you for coming today, and I appreciate your comments as well. I think they've been very illuminating. I would like you to address one area that you haven't talked about yet, and that is the use of the additional tools that we've seen in recent years, both the Guardian Ad Litem program and the use of forensic psychologists, and how that can help you as this finder of fact reach a good decision for the best interest of the child.
Well, and I noticed there was a proposal,
Yeah.
perhaps that you never use those unless you find unfitness or something. And in some regards, that's kind of like the tail wagging the dog, because it is through the use of guardian ad litems or forensic psychologists that you're able to find whether there is a problem or not. Because as you can imagine, in domestic cases, particularly when they're fighting about the kids, neither parent has a whole lot of good to say about the other, and their stories are differing, totally opposite, and they generally all have witnesses. So as a judge, we're trained in trying to decide credibility, but we're not gods. We don't know it all, and so how do we get around that, and how do we get to the child hearsay, find out what the children think, and oftentimes that is through the use of a guardian ad litem, because the guardian ad litem is in many cases a lawyer, sometimes not. But they are able to go and talk with the children, to talk with the children's friends, parents of friends, teachers, counselors in school, to find out really what's going on. And then that guardian is able to come to court and to not have an allegiance to mom, not have an allegiance to dad, to have his or her sole allegiance to the child, and to basically represent to the judge what they think is in the best interest of the child, and to be subject to cross-examination. by the child's lawyers. By the mom's and dad's lawyers, as to how did you reach that opinion and what did you find. And it allows us really to do a lot of things indirectly that a strict adherence to the Civil Practice Act, the rules of hearsay and such, would never allow us to occur unless we want to bring children into the courtroom environment and have them testify. Psychologists are used probably less frequently than guardians because they're much more expensive. The good ones are tremendously expensive. My wife is a psychologist, and I've been telling her for years to get into this line of business. But her position is she gets cross-examined at home enough, and there's not enough money to make it worth her while to go to court. But I think they're good because they, I'm probably personally less convinced by social testing. My wife would forgive me for say that, but I think they are beneficial in a lot of ways to have those tests. They're kind of like talking about the MMPI-2 test and objective test, but every objective test has a subjective interpretation that goes along with it. But I think that that those are good things to use. I would hate to say you can never use those tools unless you have found someone to be unfit, because sometimes they help you find out who's telling the truth to start with. But the other limiting factor of them is they're very expensive. We don't have money for them. Most counties do not provide money for psychologists and guardians, and I only appoint them when I'm clear that there's a way to have them paid for. And so, unfortunately, it is more of a middle and upper middle class phenomenon that you see them used. Now, juvenile courts have access to guardians, and sometimes judges will transfer cases in my circuit to the juvenile court when you have lower socioeconomic folks getting a divorce with a lot of serious allegations of abuse and such. And then the guardians that work for the juvenile court can conduct the investigations.
One last time.
Yeah, one more.
As a Superior Court judge and a member of the council, is there anything else that you believe that the legislature can provide the court system in terms of tools that will help the process?
Well, I can think of a lot of things, but like guardians and psychologists and things like that, but they all cost money.
I figured since you're here, if you take your time, maybe we'll give you a chance to.
Well, it would be, it'd be great if every Superior Court judge, or at least every circuit, had a state-paid guardian who could in limited number of cases investigate cases in lower socioeconomic situations where parties can't afford a guardian. That would be great. I can think of a lot of things like that, but most of those things involve the expenditures of money.
About $60 million a year to the public defenders, maybe they could take it.
Yeah, maybe we could get some of their money, we'd be happy.
Okay. Representative Butler.
I wanted to go back over something that you had mentioned earlier. You gave out a scenario, and I want to go back over it and kind of put it in my own words and ask you some questions about it. This has to do with legal custody. You had given out a scenario where we, in an ideal world, which this does happen actually in some cases, where you've got two parents who agree to joint legal custody, joint physical custody. Now, in my layman's mind, when you do have joint legal custody, that basically means both parents have equal say-so in the decision-making process, correct?
It does to the final point, which is if they can't make a decision, case law says we're supposed to designate one of them on all issues or divide the issues that person, who gets to make the final decision.
Okay. If these two, and you also said, I believe, correct me if I'm wrong, that if the two parents agreed on that final point, that if they cannot come to an agreement, that they would subject to binding arbitration, that you can't do that.
That's right.
Now, is that black letter law? Or is
that is black letter law in the case law, because the case law says is that the judge has to make the final decision. And so, now, let's back up a second and say this. If let's say they can't agree on something, and they say, well, let's go get Susan down the street to make the decision. She knows us both. She's a friend of both of us. And if they go to Susan and Susan makes the decision, and maybe it was the kind of thing where she's going to have to decide in favor of one or the other, and the person who doesn't win the battle is not going to come to the judge and complain about it, then the fact that they went to Susan's okay, because it never comes back to me. But if it were to come back to me that they couldn't agree, the fact that Susan might have decided that has no bearing on the ultimate decision that I have to make. It's kind of like a police officer who investigates a crime scene. You know, he goes out and investigates a crime scene, and he decides that Jimmy committed the crime. Well, you know, his opinion, I can listen to it, but his opinion is not the final decision. And so the law says that the Superior Court judge has to make the final decision, and it says that in their settlement agreement, when everything's going good, maybe they want a divorce and they agree to all of this up front, that if that settlement decision decides, and it says in there that some third party is going to make final decisions about their children and custody and things like that, if they can't agree, I am told in case law to reject that and to say they can designate one or the other of them to make the final decision, but it has to be one of them or me. It cannot be some third party. So that's pretty good. As it relates to custody issues now, like a common cause you see, parents have to live within 30 miles of each other. If one parent decides to move to more than 30 miles, then they've got to try to agree on the custody issues, then visitation, and if they can't agree, then they'll go arbitrate it. That's not a valid legal clause as I understand it, because the decision has to be made at the time, meaning the time in the future when they move, and it's got to either be them agreeing or the Superior Court judge agreeing. And that's why I like the idea that if they can agree now while they're all getting along, that we're going to allow some third party to make that decision for us. I think that'd be a good thing, and it certainly would cut down on the amount of cases that we have to hear.
So what you're saying is now, I've got to what you said with what the law is, but you do believe that if the two can agree to settle things through arbitration, if they cannot agree, that would be a good idea.
I think it's a good thing. I mean, I tell litigants all the time is that I'm no smarter than them or anyone else. I have to make the decision because I'm the judge, and if they can't agree, then the law gives me that responsibility. But if they want to confer that on some other third party, someone who perhaps is better trained than me in custody matters, and child welfare matters, then I'm perfectly fine to go along with that. I mean, we're trusting that they know what's in their children's best interest, and if they think it's in their children's best interest to have some other third party make those custody decisions, then why not?
Okay, well, I'm going to tell you that I agree with you wholeheartedly, and the reason why is because, and this is just my viewpoint right here. Obviously, there's no legalness behind this, but if you give out, or if you were to award or put into an agreement that you do have, that both parents have joint legal custody, if you give one parent or the other final say-so, you have not awarded joint legal custody. I mean, you may have wrote it down on a piece of paper, and it may be inked in or typed or whatever, but you have still basically given sole custody out to one person, because if they have the overriding decision-making capability, then you do not have joint legal custody.
And there are many parents that will approach it that exact same way. That's the most common complaint I get on the joint legal custody issues is the parent who doesn't have final say will come to court and say, Judge, he's made all these decisions, and then he sent me an email, so he obviously didn't consider my input. And so you ought to give me the final say-so, because I will have an open discourse with him on what these issues should be before I make a final decision. And so, I think your point's well taken.
Thank you.
Judge Ray, thank you for coming. I have just one couple of things that time is moving quickly here, and so let me try and be brief. There is a recommendation in this set of constitutional issues that we're looking at that said that unfit should have an evidentiary standard of clear and convincing evidence. Is that the way you approach it now, or?
Well, no. I mean, the law would be clear. The law would be preponderance now, and that's what's most believable. I can. The distinction between the two is hard to express. It's easier for me to tell a jury what the difference between preponderance is and beyond a reasonable doubt, which is the criminal standard. Clear and convincing really is sort of nebulous. It just means, to me, it means you got a pretty good feeling that you're right. Not that you just had to decide who was going to win and who was going to lose, because that's really all preponderance is who's most believable. But you're not just who's most believable, but that you got a pretty good feeling that side of the decision is right. I think that's something for y'all to talk about. I will tell you that as a judge, I'm not going to declare somebody unfit just because I believe he is 51% unfit to 49% fit. I mean, because unfitness is a stigmatizing situation that can lead to termination of parental rights altogether, and I've got to have a pretty strong, compelling reason to do it. And so I'm not going to do it just because I have to make a decision, which is what happens in civil cases.
Another question has to go to that issue. There's I've heard that in many cases there's a criminal charge that comes along with a divorce proceeding, and the question is, I guess, whether there are sanctions for bad allegations or false allegations.
Well, what typically happens, and I mean, it's there, and judges will freely tell you that there are domestic violence cases that are filed that are there to aid in the divorce case. I think everybody could agree to that. I think, there are various parties in this room, folks I remember from when I was in the General Assembly. I think everybody would agree to that. The problem that we as judges have is knowing which are those cases. I mean, if you shut down the family violence courts, the ability to get TPOs and whatnot, because you think there's abuse in the domestic sense, you're going to inevitably have situations where people that need them can't get them. So I don't know the answer. If there was some authority in the law that you gave the judge the ability to decide, for example, maybe with a higher burden, higher standard, that if he felt like a claim was brought in bad faith, that he could have sanctions that involves attorney's fees that maybe is not currently provided for in the law, then that would probably be a good thing. I can tell you in close cases, though, maybe let's say an allegation is brought and we don't believe it, but again, it's that situation where we just barely don't believe it versus barely believing it. We're probably not going to institute sanctions because we don't want to chill the ability of people that are really in fear of their lives from going and getting those domestic violence petitions. But again, I think everybody can agree there are bad claims filed. There are some lawyers that will draw up the divorce case and tell their client to go down to the courthouse and file a domestic violence petition. They won't participate in it, but they'll guide them to do it. And there's certain lawyers that you see just about every case. There's an allegation of domestic violence that occurs in the quasi-criminal domestic violence arena.
Final question would be just a quick summary of what the parenting plan effectiveness is in terms of these proceedings, and any structure to that you want to comment on.
Well, to me, the good thing about the parenting plan is it would force the parents to look at it from both sides. Look at it from not only what would I be receiving, but what would the other side be receiving as far as time with the kids, exchange of the kids, that type of thing. Oftentimes, in very close domestic cases, I will tell or will ask both the mom and the dad that if I rule against them as to custody, are they going to be happy with the proposal that they have set out for the person who's not going to have custody? Sometimes they'll say they would be. Many times they will come back and they'll either settle that case or they will get something a little bit closer to the center of the division of time. And not that there shouldn't be an 80%, 20%, or every other weekend. I mean, the every other weekend thing is really rare today. I mean, that used to be the standard. Today it's more like Friday to Monday, Thursday to Monday type thing is sort of the status quo. But if you force them to think about it from both standpoints and put it in paper, then number one, they've thought about the other side, and number two, it's going to be hard for them to feel like they've been shortchanged if they end up getting what they have proposed the other parent to have.
Well, thank you, Judge Ray. We really appreciate you coming down here this morning. I know you've got some jurors waiting back up in Gwinnett for you, but we do appreciate taking your time to come down here and share your views on this with us. We appreciate it very much.
Thank you. It's my pleasure.
All right. Now, we let the first witness, Judge Ray, go a little longer than what we would probably normally do, giving him a senatorial. I don't know. Does the House still give senatorial privilege around here, or what? What do you think? I don't know. But we're sitting here at 11 o'clock, and we have 9 witnesses to go. What we'd like to do is to try and not duplicate comments that have already been made. In other words, if Judge Ray has said something that you either disagree with, then you need to speak to that. But if you're in agreement basically with some point that he has made, we probably don't need to hear from that unless you feel it's vitally important. But we'll move next to I'm going to say judge, but this is not a judge. This is an attorney. Sheila, Edlin. I have my glasses on here. Sheila, you're chair of the State Bar of the Georgia Family Law Section, correct?
Yes, and as such, I can only speak either personally about my views or answer technical questions, since the State Bar has not sanctioned anything in terms of any proposed bills. So I would just like to make comments and answer some questions. From a personal perspective, the standards for custody, that is the best interest of the child, are nebulous at best, and they need definition in the law. We need factors for the courts to consider and for litigants to understand, other than just this old-time general statement of whatever is in the child's best interest. The case law has helped define that, but we need to give more constitutional clarity to the standard of best interest of the children. We need definition to that. We need to get our hands around it. While the best interest standard has never been attacked constitutionally, because us dumb divorce lawyers never passed constitutional law, it really needs to be looked at by the legislature. I would urge that. Two, in terms of the big issue about presumptive joint custody, I don't believe the law favors presumptions at all. And I think it's insulting to judges to make them presume something. And I'm happy to report that after almost 30 years of practicing law in Atlanta and its vicinity, there is no presumption in most judges' minds about custody. I will say categorically, the cases I have tried, men have won the majority of those custody cases. And 25 years ago, that was not the case. I think judges are fair-minded now. They're open-minded now. For the most part, there are always bad apples to this rule, and I don't think we need to legislate because of that. But I believe that the judges now are treating parents without a presumption in their mind. And I don't believe the law needs to tell judges that there needs to be a presumption. The law is good now. It's clear by case law the judges must consider joint legal custody, and they are. I believe we have in Georgia a de facto joint custody policy among judges, even though it's not de jure, it's not in the law. I believe judges, I cannot remember the last time that I had a judge in a contested custody case award anything but joint custody. Only in unfitness, when there's been clear unfitness, has sole custody been awarded. And I'm happy to say that. And I'm happy to say the judges have got it without the help of the legislature. The judges are generally in tune now to what's going on in society. And they're not just giving the old standard, give the mom custody and the dad gets nothing. The idea that, and I would ask you as a practitioner, the idea that we now have, starting January 1, new child support guidelines is frightening to lawyers. It's frightening to judges. We have a lot to work on. We are rapidly trying to ramp up the education of all of us when we begin to implement those guidelines. The guidelines are going to help the custody cases, I believe. I think we need some time to let the guidelines work their way up and see how those fights about custody are affected by the guidelines. And I will predict to you that there are going to be more cases where the fight will be minimized because of the guideline, that is the custody fight. I think child support is going to be, the child support is really going to help the custody cases, I sincerely hope. We need to define what's in the best interest of the child, as I said. We need to and we need to have a legislative finding of factors for a change of custody. right? We have these general statements of law about a substantial change materially affecting the welfare of the child, but we don't know what the heck that means as lawyers. It's very hard to predict without factors what a judge may do on a change of custody case. And I would ask that this legislative body consider working with the bar in establishing factors for both the change of custody and the best interest standard. We need that as lawyers. Judges need it. Right now, it's just amorphous. And I think that if it's tested, the constitutional tax would be probably valid. The issue of relocation is a hot button. The Supreme Court of Georgia, as Judge Ray said about a year ago, allowed for the first time, thank goodness, a relocation to be enough to look again at the change of custody issue. Imagine that having never been a factor in the law. Imagine that. And the legislature has never made a list of factors. I have some experience. I don't see any familiar faces. Maybe Mr. Earhart was in it. But we, as the bar, for years, I came down here dozens of times, it feels like, to try to get the legislature, with I think it was Senator Tanksley at the time, to try to get the legislature to adopt factors and adopt a relocation statute. The American Academy of Matrimonial Lawyers has such a model statute. It was so politicized that it failed. We need a relocation statute in Georgia. We are woefully behind. And we would be happy to help as the bar. And I know the Academy of Matrimonial Lawyers would be happy to help. It's just so politicized that we couldn't get any consensus about what are the factors, or whether there should be a presumption to favor or not to favor a relocation. But we need the policymakers, all of you, to help Georgia decide, what do you do when a parent wants to move? Well, all the parent can do now is the non-relocating parent can say, I want my kids to stay. Well, do we as Georgians, do we want parents to be required to stay, or do we want parents to be allowed to move? And what are the factors that we need to look at to determine that? Don't have that in Georgia. Big problem. The age of election, Judge Ray sort of hit it on the head. I will say from a practitioner standpoint that I never understand how a parent can have a conversation with a 14-year-old and say, son, sign this piece of paper, please, and that's your ticket to a new car. Okay? That's your ticket to being able to go out. That's your ticket to having alcohol in the house. How does a parent have a conversation with a 14-year-old and say, you need to sign this election? That is disgusting. And that's the policy of the state. My opinion's not as chairman of the state bar. It is just disgusting that we as Georgians have always, since I've been practicing law, allow now 11-year-olds to go into the courtroom to say, I really want to live with daddy, without really understanding. The judges don't understand how these kids are pressures put on them. I say remove the elections completely, get the children out of the courtroom. Okay, now how do you do that? It's expensive. If there's a change of custody case, I don't want to see a child talking in the back room with Judge Ray. God bless him. He's an excellent judge. But as a lawyer, I'm going to watch him. You know, he said, and this is very common, that the judges don't want the lawyers there. Well, we're not bad people. Okay? That's the presumption that I hear by judges, that we're going to do something inappropriate or the child will feel restricted in some way. The law, thank goodness, says lawyers can be there, but we have judges like Judge Ray that say, and they have lots of persuasive power because they have the ultimate decision. They say, well, and Judge Ray said it. He's a friend of mine. I can speak publicly about that. Well, if you're going to be there, then I'm just not going to do it. Okay? Well, I got a solution for that. And the solution is simple but expensive at times. That is to support the guardian ad litem program. Okay? That keeps the children away from the courtroom. That allows the impossible to find witnesses, that is the school teachers, they speak to the guardian. I can't talk to a school teacher. School teachers don't want to listen to lawyers, but they'll listen and they'll talk openly to guardians. I say we need to put into law if we talk about presumptions, the policy should be, let us favor guardian ad litems. And let's start a statewide training program for them. Let's find the money, if we can, please, to help these families. I know we have a lot of competing interests in the state. Very important, the guardian ad litem program. Judges being judges, they want the last say on custody. That is disgusting. Why the state needs to be in the middle of a parent's agreement and withhold their agreement because some judge doesn't like it. I don't want the state involved in my life if I'm getting divorced. My wife and I have agreed. We have figured it out. We don't need your help. You take that agreement, you place it in front of a judge. The judge says, don't like it. Ridiculous. Had it happen last week. Judge, I'm pleased to announce the parties have entered into an agreement. The judge is sitting there stubbornly listening. After I finish, the judge says, rejected, and comes up with something that is not understandable to anyone. Why we allow judges to have the final say needs to be removed. I believe this strongly. Parenting plan is part of the Model Relocation Act. It's a wonderful concept. Make the parties think about it. How novel. Make them think about, before they come to court, what they would like. Okay, now the lawyers have, and the parties have the burden of filling out this incomprehensible child support form. Okay, we're going to have to start. That's a new standard we all have. We got to, before we come to court, we have to learn how to use a computer. Judges are frightened by that some. But let's add the burden. Let's up the burden, and let's make the parents come to court with a proposed parenting plan. Let's make them think about it. It's surprising how many parents don't do that, and the lawyers don't do that. I think it would be a good policy to require it. Finally, and then I'll answer any questions, attorney fees in change of custody cases needs to be sanctioned by this legislature. There's so many crappy custody cases, change of custody cases, where the lawyers only have a remedy for attorney fees by doing 915-14, which is generally frivolous litigation. I would ask that the legislature allow the discretion, open the door for the first time, allow the discretion for the trial judge to award attorney fees to the prevailing party, just like we do in a modification of support case. Allow for a prevailing party to have attorney fees awarded. And I thank you for listening to me. I'm impassioned by this. I've done this a long time. I have strong feelings.
I wouldn't have believed that from your from your testimony. Well, thanks an awful lot. I do appreciate that. Let's go to questions from our erstwhile group here, starting on the right this time.
Just a quick.
Representative Lindsay.
Thank you. Just a couple of quick comments. When is our third and final hearing? We're supposed to try to come up with some substantive.
October 26th.
Let me recommend to you, given the fact that you've suggested that we need to come up with some specific factors to be considered under the best interest of the child, since your section of the bar knows more about this than anyone else other than the judges, that by that date that you get together with your board and give us some proposed language for both the factors for change of custody and the factors in determining best interest of the child. That would, I think, would be very helpful to all of us. Also, sort of an editorial comment as well. What you were saying regarding the lack of structure in terms of what exactly is the meaning of best interest of the child or the factors for change of custody, I think can also be dealt with if we had a little bit more case law. And we opened up the appellate process and got some more case law so that the appellate courts could give a little bit more definition to those terms.
Can I just respond to that?
Yeah, please.
I would, as a lawyer,
Yeah.
given the 25-year history of no case law, can't wait.
Yeah.
We need the legislature to do it. Please.
And perhaps it just real briefly would help the panel perhaps if you would sort of explain how attorney's fees can be awarded in just about every other aspect of divorce cases except in battles over child custody.
That is a correct statement.
And so when we're talking about getting attorney's fees awarded in child custody cases, what we're talking about essentially is making sure that in custody battles are treated just like any other
Should be.
aspect of domestic
It's a
law.
free shot right now,
Yeah.
my friends, for a change of custody case. There is no paralyzing problem at the end. If you lose, you just lose. I think if there's a potential sanction of attorney fees, a lot of these weaker cases will be thought about a lot harder. Yeah, well, we have to work
Other
on that.
questions?
Just
Yes, Representative Earhart.
very quickly, you made a couple statements. I think I understood where you were going. Statistically, let's put it this way, the statistics I've seen for the metro area with respect to custody cases, yes, they're changing, but they're changing extremely slowly with respect to the balance that you mentioned.
I strongly disagree with that.
We can share statistics.
Okay.
So maybe
I'm talking experientially.
experiential, I'm talking statistics I've seen. So we can agree that we may have different bases for information. You said that we don't need to legislate because of the bad apples. How do we have a body of law then, because without a direct appeal, without the capacity to on a bad apple, what do we do? I think what you're saying, and correct me if I'm wrong, is that some of the other changes we're making will get there. But where does that individual go who is the victim, quote, of a bad apple?
I have no strong answer for that. I will be happy to report that the bad apples, in my experience, are very limited, and I hate to see legislation wrapped around a very small quantity. It's those bad apples that are the war stories that lawyers talk about, okay? We're warned about it, okay, ahead of time, but that's a policy decision for this panel. Tough problem.
Other questions? Yes, Representative Manning.
I'm a little concerned. You said that you would support the guardian ad litem.
The expansion of the guardian, I think that there should be law and resources for courts to appoint guardians. Right now, we must request them. They are in the discretion of the trial court whether or not to appoint a guardian or not. Trial courts are not as willing as I think they need to be to appoint guardians. And I'm happy, as Representative Lindsay has asked, I'm happy to establish or try to establish a set of factors for the courts to consider. But in my judgment, the guardian is the protector of the family. And what I would hope would happen is the guardian speaks for the child, and therefore we don't bring children to court anymore. That is a real problem. To see a child in the courtroom, to me, that's an event that child will never forget. And by bringing a guardian into the case, that will largely reduce that need.
I'm curious, is a guardian not equal to or on the same par as a CASA volunteer?
A what?
A CASA?
A CASA?
Those court-appointed special advocates.
That's outside of my area of expertise. The guardian represents the best. The child the guardian is an advocate for the child.
Well,
Okay.
so is a CASA.
Okay. Well, then if they're the same, I don't know. You'll have to.
There's a distinction generally in juvenile cases.
In juvenile cases, when CASA generally used, while in custody cases, it's usually a guardian who's a lawyer.
Let me just figure out then. In other words, you think that if you have this is the child's lawyer. You've got the mom's lawyer, the dad's lawyer, so the guardian is the child's lawyer.
Well, let me answer that with a little expansion, okay? It's not defined. Your question is a good one. The role of the guardian is not defined in the law, and it's done on a case-by-case basis. And what I found is, and now the Supreme Court has entered some rules about guardians, okay? And what I have found is that the courts don't know what the role of the guardian is. Is the guardian a lawyer, or is the guardian an investigator? okay? And we need a statute that tells us what a guardian is, okay? Right now, you don't have to be a lawyer to be a guardian. We need to have some standards, okay? So what we have now is the guardian comes in to the courtroom with a report written. The court generally reads the report and asks the guardian to come and to answer questions about what the report says. The report is a finding of facts and a recommendation. That's another issue that needs to be considered, whether we want guardians to make recommendations or just to find facts. Is the guardian able to present witnesses at trial? We don't know.
Well, I'm concerned because I think your reference to this came under the guise of the age of election, doing away with it completely. So would every child have one of these, and how young would the child? I mean, it would seem to me like every child would need that kind of thing.
If I just say it clearly, I may have been confused, but the age of election is a perfect reason why we need a guardian, but we need a guardian every contested custody case, no matter what age. We don't want children in courtrooms.
I just have one question.
Yes, sir.
And that's just a follow-up, and probably it's my lack of understanding. You seem to mention parenting plan, parent agreement, so on and so forth, almost interchangeably to me. With regards to that same area where you said that their parents' view of the agreement should be the final arbiter of what happens. In other words, you take it out of the judge's hands at that point in time. Are we all talking about the same thing? Parenting agreement, parenting plan, and so on and so
A
forth?
parenting plan is a proposal for a custodial arrangement.
Right.
Okay, so that's how I'm using that term.
Okay.
Each parent presents a plan. Then the way the system works now is the court will make the final order. Okay? And what I'm trying to say, if I didn't make it clear, is that if the parents agree to the plan and the judge rejects it, that's a problem.
Okay.
All
All right.
circumstances.
Right.
Why would a judge object to something they had agreed to?
I would like to know the answer to that. I have never found, I mean, as shocking as it is, and this goes to Representative Earhart's bad apple, that happens. That happens, and judges get annoyed with, I mean, I've had it where the judges were just
Then we need to elect juvenile judges?
elect Superior Court judges.
No, I meant juvenile court judges.
Oh, I'm speaking on the Superior Court side.
Well, both.
Well,
We do like them.
to be clear, in the vast majority of contested custody cases, the Superior Court judges are doing them. Rarely are the cases referred, as Judge Ray said they do sometimes in Gwinnett, rarely are they referred to juvenile court. Okay? But I'm not here to slander all the Superior Court judges, okay? I want to be clear about that. I think the process is working.
You are on TV.
You hear that, Judge? But you know, sometimes judges have too much power in their own minds, okay? And they think they know better than the parents. And that's a real problem, okay? That is a real problem. I don't want this state to allow those type of judges to take consent agreements that make sense to the parents. It doesn't matter whether it makes sense to a judge or not. The judges may be saying to themselves, well, if I sign this agreement, I'm going to guess now, if I sign this agreement and enforce it, then I'll see these people again back in court. Well, so what? That's what you're paid to do. Okay? They've agreed to do it. They've agreed. Give them a chance. Keep the government out of their lives. The government's way too involved in those type of situations. We need to give the power back to the family.
One final question, and
Yes, sir.
that's this is almost anecdotal, but it's the bad apple issue. Should we allow retired Superior Court judges who do not stand for election to adjudicate these cases?
That's a tough one because the other side of the coin is, do we make these people wait longer?
Right.
Okay, so judges, I believe, are not bringing in the senior judges because they have nothing to do and they want to go on vacation. They're trying to move their caseload along.
Right. I agree
So
with
that's a tough call.
But in this particular area of concern.
I have had more bad experiences with senior judges than with elected serving judges. More bad experience, okay? Particularly in this frightening area of custody, where you have more provincial, more traditional, more conservative senior judges putting their value judgments on modern-day families. It's a problem. I thank you for that question. I don't know how you deal with it, because I think the Superior Court Judges Council will be attacking you if you try to take that away. But it would be I would rather, when I see a Superior Court, a senior judge show up, I tell my clients, because if they're in the modern-day cases, I say, let's wait. Let's wait. So I'd rather I don't like it to explain to a client why some unelected person is sitting in judgment of them. That's very disturbing to me. That's a tough discussion. So appreciate that.
Mr. Edlin, we thank you for coming down here today. We appreciate all your efforts in years past and in the current year.
We'll continue to help our
ball.
families in Georgia. Thank you.
Okay, very good. We're 11:30 and we're moving on here to Mr. Richard.
Take a break.
Oh, you want to take a break?
Yes, I like a glass of water.
5 minutes break. Let's get back here by 11:35, if at all possible.
our statute. And there is no right to appeal there except discretionary. And so you have to make an application for a discretionary appeal, which can be accepted or not accepted, and the vast majority are not accepted. And I think, like Judge Ray, as well as Mr. Edlin, I think most family law attorneys and people in the field very much want the right to appeal for clients, since there's certainly no matter more important than custody.
Mr. Chairman, can I stop you there?
Sure.
I want to make sure I heard that correctly.
Yes, sir.
I'm sorry,
Recognize
only,
you,
but
Mr. Chairman.
I want to make sure I heard that, because the agreement that I thought we had with respect to the appellate jurisdiction was that not only the Supreme Court, but that the Georgia Court of Appeals would take those. That was the basis for the withdrawal of my amendment on.
No,
You're
sir.
telling me that the Georgia Court of Appeals is not accepting those?
They are taking them on the purely
Discretionary.
discretionary. They are not part of the pilot project. I'm
Thank you for giving that
absolutely
information.
telling you that.
I've been lied to. Now,
That I won't comment on, but the Supreme Court voted, it was actually 6-1 to initiate the pilot project about 2 or 3 years ago, I guess now. The Court of Appeals has, to my knowledge, never taken up the issue, but we still must go through the old discretionary appeal standards for any matter that comes to the Court of Appeals. And so if it's custody arising from an original divorce, it'll go to the Supreme Court and it will fall under that pilot project. But if it's a post-divorce, normally a change of custody action, those cases, by virtue of the statutes, goes to the Court of Appeals. And it's a whole different standard of review or likelihood of getting any review. And I think most attorneys would agree that a review of an issue as important as custody is paramount, and anything you can do in that regard, I think, would be appreciated.
While we're here, do you have any, I mean, you've anecdotally told us that they don't get hurt, basically. Is that 95% of them, or
I know when
7 or 80, or what? Do you have any
When
idea?
we were fighting with the Supreme Court trying to get them to initiate a pilot project, I remember the statistics there were about 85 or so % were declined. And when you talk to the Supreme Court justices, they indicated, well, we're taking the good ones. But if you talk to the attorneys, you go, wait a minute, these are ones that had merit, had areas of the law that we need clarification on, and you're not taking them. And talking to justices since the pilot project, they've been very receptive to it and acknowledged that they were probably missing a lot of cases and a lot of legal issues that they needed to deal with. Their concern was a floodgate of additional appeals, and thankfully that has not happened. And I think that's made it go more smoothly so that they didn't become overworked in terms of that. But the Court of Appeals, I don't know the exact statistics. I would assume they were similar to the Supreme Court, but I don't know that specifically. But the vast majority are rejected.
Please continue. Okay, thank you.
The use of guardian ad litems, as it ties in with the 14-year-old election statute and the 11-year-old expressing an opinion, since that's come up, Judge Ray, I know, indicated that he thought the 11-year-olds being able to express opinions was beneficial. Mr. Edlin said the opposite on that. I think Mr. Edlin's closer to correct, because what we have seen is more manipulation now of just younger children, and the same problems that exist with the 14-year-old statute in terms of parents misusing it by manipulating children. Now you have the opportunity to manipulate even younger children. For example, today I got in the mail a motion for the court to talk to an 11-year-old in an upcoming custody case. Why is that? Because the guardian and the psychologist who's done a custody evaluation have both recommended that dad have primary custody. Well, mom's looking, the kid lives with mom at the present time. What will be said to that child between now and then? Yeah, we can all hazard our own guess, but I can guess what the child's preference will be, regardless of the facts, by the time we get to court. And the more we take children into court, the more we subject them to pressure, no matter what. And even if we try and do it very benignly, as Judge Ray talked about, with no lawyers there, it's still, the child knows what's going on. They know they're in a court. They know they're in the judge's chambers and the importance of what's being said. And It's difficult to keep matters secret in that regard because the parties have a right, a due process right, to know what evidence was presented to the court that may have affected the court's decision. You can't really have an effective review unless you know what actual information the court received in that regard. And so there is a problem with the age of election. I think its time historically was very necessary because you couldn't get judges to award custody primarily to fathers, and this was a way to ensure it when a child was of a particular age. But I think that time we've evolved, fortunately, past that being a major problem. Mr. Edlin was upset about his agreements not being approved when the parties agreed to them. And the law now simply requires that the court review agreements as it pertains to custody and child support issues to ensure that they're appropriate. And I don't think that should be changed at all. There are cases where agreements may be submitted and the court has a very good reason to have questions or concerns. You may have cases where there's spousal abuse and one party's been coerced into a settlement that's not in the best interest of the child. Now, that's going to be rare. There's no question about it. I've never had an agreement rejected by the court that was submitted in 25 years of doing this. And I think it's going to be a very rare instance when it does occur. But there does need to be some level of judicial review to make certain that the child's interests are being protected. Because realistically, in a divorce case, you have two parties who are protecting their own interests, and assuming there isn't a guardian in the case, there's no one necessarily protecting the child's interest. And that's part of what the court's job is in reviewing to make sure child support is appropriate, as well as that the custody and visitation arrangements are appropriate. There was a question earlier about legal custody and decision-making. Joint legal custody under our law does not mean joint decision-making. It means joint input. It means the parties are supposed to confer and attempt to reach mutually agreed upon decisions. Then, if the parties after that cannot agree, there has to be some mechanism by which custody issues can be determined. Now, my take of the case law is a little bit different than Judge Ray's. He indicated he thought that the Supreme Court had said it had to be between the two parents. You had to designate one. I'd have to look back, but my memory of it is a little bit different. The Supreme Court took a case where the parties were left at an impasse. They had to reach mutually agreed upon decisions. And the difficulty arose because what happens if there is no agreement and a decision has to be made? And what they said is you can't leave the parties in a stalemate type of position. For example, some agreements say you'll go to mediation. Well, that's wonderful, but mediation doesn't necessarily break a tie. It just requires discussion. And so the Supreme Court said agreements shouldn't be approved that don't have a tie-breaking mechanism. So in many agreements, we will have, for example, on medical issues, if the parties disagree, sometimes the children's pediatrician will be the tiebreaker. It may be a school counselor if it's an educationally related decision. Most of the time you're going to use parents, and most of the time, hopefully, they're going to agree and it isn't going to be a problem. But what the Supreme Court was trying to guard against, and I think appropriately, was leaving the parties in an absolute stalemate where no decision is made. I had recent litigation where the parties' agreement said they each had equal decision making, and they disagreed about school. Well, we ended up back in court and threatening schools and other things where they were trying to admit the children. And so there needs to be just a mechanism that alleviates any kind of impasse. And I think that's all the Supreme Court really was saying in that particular decision. On attorney's fees, I think, again, most practitioners are going to agree that there needs to be the ability to award attorney's fees. I don't, from my understanding of the law, believe there's any prohibition. It's just that with the statutory authority that authorizes awards of attorney's fees, custody and visitation cases are not listed. And so it's simply an absence of the law as opposed to changing the law. And the Supreme Court and Court of Appeals have held previously that they just don't have the authority for the trial courts to make such an award. So it's not really that anyone's asking you to change a law that is out there in that regard, but to establish that this is kind of a loophole and a gap that's fallen in between, and there's simply no authority to support the award of fees. Obviously, custody cases can be used in different fashions, sometimes for good purpose, sometimes not necessarily so, and the court ought to have the discretion to do what's appropriate under the particular facts of that case. I don't think there's any question the law has been evolving significantly. I started practicing in 1981. We had no joint custody agreements. I don't think we knew what it was. It was some kind of newfangled idea out of California that we read about, and that was about all we did. But it's evolved now to where the I'd say 98% maybe of cases I deal with, joint legal custody, meaning the right to information and the right to confer, is the rule. It's a very rare case that even that's tried that a judge isn't going to award joint legal custody but still break down who has decision-making authority. Joint physical under the code in Georgia has a specific meaning which talks about is to assure the child of substantially equal time in contact with both parents. Truthfully, those words are used for cosmetic effect a great deal. And any lawyer can draft you a joint physical custodial agreement that gives you minimal visitation, or a case where there is a primary physical custodian and a secondary physical custodian where it's very close to 50-50. And so the terminology is frequently misleading, and clients frequently come in saying, I want joint custody. And the first question I ask is, what do you actually mean? What do you want? Don't give me buzz phrases. And one of the problems in this area is that there's a lot of times a lot of attention given to the phraseology and the title versus the substance of it in terms of that. We do have some standards regarding relocation. Justice Sears, with the Supreme Court, listed criteria that should be considered in a relocation case. I know that one of the issues before you is whether to restrict a party's right to move from the state of Georgia. Georgia law currently, and for decades and decades, has held that there is a constitutional right to travel, and therefore the state does not have the right to restrict a party. Now, with the recent Supreme Court decision of a couple of years ago, the court can, however, change custody if the facts warrant it. And I don't know of anyone who doesn't believe that that was a long overdue decision, because a relocation is obviously a substantial change in condition. At the same time, based on the facts of a case, it may or may not warrant a change of custody. You have to look at the individual facts in terms of that. The question of domestic violence and false domestic violence is a serious problem. It is absolutely utilized to gain an upper hand. If a party wishes to get the other party out of the house and thereby gain temporary custody, you file a family violence action. And you're going to get an ex parte, an order without any opportunity for the other side to be heard. And then you're entitled to have a hearing at a later time. It's extremely difficult at that next hearing to get a judge to alter something, because what you have almost always is a swearing match. One party says something happened, the other party said, no, it didn't. And it can be a real problem in divorce cases, because the judge who's hearing your divorce case is very unlikely to be the judge who hears the family violence, because normally you have a magistrate court or some other level of court that's actually hearing the family violence case initially, and even at that 10-day or 30-day hearing, depending on which county that you're in. And penalties, I don't know how you mandate them, but certainly the courts need to treat harshly false allegations, because it's far, far too common. And it's extremely difficult to defend against, because you can never prove something did not happen. You can't present evidence that I didn't hit that person or I didn't shove that person. And the courts are very conservative, and understandably so, about being safe rather than sorry. They don't want to read later that something horrible happened where they didn't act and they had the opportunity to. And that's natural. We would all feel that way. But it puts the person who is the defendant in that situation in a very, very difficult position. And in the rare cases where you can really show it was done with evil purposes, there ought to be a significant punishment. There's no question about it. Same is absolutely true with false sexual abuse charges. And again, it's going to be hard to know which ones are real and which ones were made in bad faith, but if the court can determine that such were made in a very bad faith, then the court should have the power to do what's necessary to punish people that are misusing and abusing the legal system in that regard.
We're going to have to finish in about 5 minutes.
Okay.
Know.
I know there's a reference to jury trials in terms of custody matters. Georgia is the only state, my understanding, left in the country that has jury trials in divorce cases, other than, I believe, Texas does allow juries for custody, not for financial. Georgia allows it for financial, not custody. And I think 48 other states don't allow it for any purpose whatsoever. I think it would be a dangerous step to have juries begin to determine custody matters. It's difficult enough, truthfully, for a judge, hopefully with a good deal of experience, to be able to make those kind of determinations. And to have 12 individuals whose qualifications are going to be random by selection through a jury process, making that type of determination, I think is problematic. I think you're seeing courts go way more towards utilizing guardians, which are a very good tool, as well as psychological evaluations where the parties can afford it and there are sufficient issues to make that a legitimate issue. The court using those much more readily because we want to use experts in areas where we may not have as much knowledge, and it's not just a necessarily common sense or lay type of approach to matters, but where an expertise really is necessary. I'd be glad to answer any questions.
Representative Lindsay?
In regards to the judge oversight, it might be helpful for the panel to remember that most of these custody cases are pro se. And so just because the parties outside the hallway have reached an agreement, particularly for the concerns he's raised in terms of one party taking advantage of the other party, it's important for the judge to have oversight when there's no lawyers involved protecting the respective rights of the parties. I believe the figure we heard from Superior Court judges is about 70% of these sort of cases are actually pro se. So that's important to remember. In regards to arbitration, you were talking about arbitrators being used in terms of a tiebreaker, but they can also be used in terms of setting up an established system for handling future disputes, so as to keep these cases from having to keep coming back in contempt actions down the road. Isn't that true?
Yes, and it's becoming more and more common because people are getting to the point where they like to know in the future if there's going to be an issue, we're going to go talk to Mr. Smith as opposed to what judge we might have or might not have, whether a senior judge, as was raised, will be there that day or somebody else, and it gives them predictability.
Yeah. And just one last comment real quickly, or question, allow you to comment on, in regards to the false claims that you discussed, one of the best deterrents I would think would be to allow attorney's fees to be awarded, because that'll cut down on a lot of false claims, won't it?
Absolutely.
Thank you.
Thank you. Representative Butler.
A little confused here. I think it looks like we have a difference of opinion, so I'm going to clarify one more time here just so I can be straight on it. Maybe something we may need to look at to clarify, but you're of the opinion that Supreme Court rules on when it comes to joint legal custody that if there is a tiebreaker, whether it's through arbitration or giving one person a right, that's okay. Like in the case that I stated, if you have two parties and they put in there, okay, we have to, agree on everything. If we can't come to an agreement, then we go to binding arbitration. You would stipulate, at least in your opinion, that would be okay.
My memory is yes. I'll be glad to get a copy of the case, and I'll want to look at it again. But
Who that case is? Do you remember?
we were trying to remember the name, and we couldn't between us.
I have a hard time remembering my own name. So.
I used to be able to. I can't anymore. but I'll be glad to get you that. But my memory was what they were really concerned about was leaving them at an impasse. And what they said was you shouldn't approve settlement agreements that don't have a mechanism by which a decision ultimately can be made.
Do you think there's some confusion on that case with lawyers, or do you think something should be clarified possibly?
Well, since Judge Ray and I have already different opinions, one of us is absolutely confused. Maybe both of us from that standpoint. So I would say I think we've proven that point.
Representative Earhart.
Let me follow up with you on the issue that Representative Lindsay, with respect to the false allegations. You used some pretty strong terms, and you said they were out of hand, and it's certainly been an abuse. I've actually seen a continuing legal education flyer promoting how to use that in the TPO in a divorce action.
Yeah.
Cynical at best, criminal at worst, in my opinion. The sanctions, the attorney's fees, is there a way to require, I'm looking for a solution. Obviously, you want to leave the capacity there.
Sure.
For obvious cases of that type of thing, but you mentioned it. So many times in some of the larger counties, or even the rural counties, they're decided by brand-new magistrates, not necessarily elected, appointed. They may be 22 years old, don't have the necessary cynicism of a Superior Court judge who's seen thousands of these back-and-forth allegations. Could we reasonably require that these be, before it is a TPO is actually done, that it requires a Superior Court judge? We've talked about the issue of senior judges versus that. At least then there's some due process for the party, or adding due process rights in there, that you have to be able to present your side of the evidence prior to that, barring some radical, blood on the floor type of thing. Is there a way to get to the due process standard? Is there a way to require those with significantly more experience to make these decisions before they're made? Put a red light on there if there's a divorce pending in the case, have it go off, and then...
I think there are two different questions. One is, if there's a divorce that's pending, I think you can certainly have a rule that any type of family violence action goes to the judge in the Superior Court who's handling that divorce case, because they're going to have some background on the matter, and they're going to be a little bit more cautious. And truthfully, if somebody abuses it, they're going to be in a better position to punish them for that abuse. The lack of due process initially with a family violence action is there for a good reason, which is, in extreme cases, you may have to have the court act immediately to protect people's lives, literally. Domestic violence is a very, very serious issue and extremely deadly. So I don't know that you can change. I don't think there's anything wrong with the law, but the judges have to use the discretion. We've seen people in cases who threw a newspaper at their spouse. That's family violence. You're removed from the home. Now, I'm not recommending you throw newspapers, but there are levels of action. And the fear, understandably, about being cautious because of that time you could be terribly wrong when you didn't act, I understand. And I'm not sure I'd react any differently if I was in a judge's position. But it opens itself up by definition to abuse. But I don't think you can do away with the ex parte nature initially of it. There's going to be the opportunity for abuse, but there need to be a lot more consequences if it is abused.
Just one more question, real quick, on the election issue. Can you suggest you told us what the downside is, but is there a suggestion here in terms of an appropriate age election?
Well, I think what you could do that would solve most of the problems there is have your 14-year-old election equal a rebuttable presumption. Have it be a rebuttable presumption. And by that, now if a 14-year-old elects, the only way to overcome it is unfitness, which is a standard that is almost impossible to ever achieve. You have to be pretty much of an axe murderer of a family member to be qualified as unfit under the laws. The standard, I've seen it once in 25 years in cases where somebody was proven to be unfit, and I won't go into the facts of it, but it's a very, very high standard. If you created a standard whereby a child 14 and up is electing, it's a rebuttable presumption, you still give the court the ability to look at why that happened. Because right now, if you bribe a 15-year-old kid, point blank. You come live with me, I will buy you a car, you don't have to have rules, and I prove that in a courtroom, I will still lose. Because that's not unfitness. It's very bad parenting, but it's not unfitness under the law at all. And so if the court had some level of discretion, a high level, but some level of discretion so that it's not a rubber stamp of a 14-year-old, which is what it is today, I think you could alleviate a lot of it, because then if the court sees a misuse of that statute, the court has the ability to do something. Today, the court can recognize the abuse, and it really makes no difference because they'll never be sustained on appeal with a finding of unfitness absent the most extreme case.
Thank you, sir. Appreciate you coming and testifying today. Okay, we're going to move ahead to this young Mr. Sears here. We'd like to have you come forward, and don't be intimidated. I'm sure you're not intimidated by that microphone. I've heard you've done this before. What we're going to do, I've got 5 after 12 at this point in time. We'd like you to hold your remarks, if at all possible, down to around 6 minutes. Is that okay with you?
Yeah.
Okay.
I probably should
Give
go
it a
bit-
try.
Intimidated too much. He's had
Give it a
all
try.
these
7.
attorneys who are used to it. I wanted to have to try to strike out. These guys get paid to be able to think on your feet like that.
You go ahead and tell us your story here.
Okay. Well, for those of you who don't know me, I run the internet organization Bill's Arena. It's at billsarena.com. It's the internet's first divorce support site for kids by a kid. Since it was first put up on April 9th of 2006, I've received and helped more than 100 people daily. I receive comments and questions from people around the world, places from the United States to New Zealand to the UK. I came here because I thought it was worth the makeup work, worth the lost time, worth the gas money, to explain to you why you need to change the law on one of the biggest issues children of today and future generations are going to face: divorce. Shared parenting may be a great way to help improve divorce-related situations. Please allow me to explain. Shared parenting is a wonderful way to help maintain balance in a child's life after divorce. It allows both parents to be a part of a child's life. The child will have more influence from both the mother and the father, helping to create a more balanced child ready to start his or her own life and become a self-sufficient, productive member of society. To start, I will probably begin with animosity or tension. Tension is very stressful and can get in the way of a child's learning or success, as I have seen personally. Causes may be from things from when the children should be with one parent or the other to who gets the equity out of the house. As the parent may live with only the child, they may vent his or her anger by yelling at the child or yelling by his or herself. No matter what, the child will notice, causing them to be stressed, as children have close relationships with their parents. As with many people I've discussed with, shared parenting helps to relieve some of this tension. Therefore, shared parenting would help a child to succeed. Many people bring up the fact that shared parenting may not work because of two parents possibly living in different school districts. Robin, of Warm Springs, Georgia, stated that her ex-husband takes the kids after school almost every day and takes them home. Other things I've discussed with people is the parent that lives out of district coming to the child's house and taking care of them, though this may not work. Other options include having the child at one parent's house for 1 week and the other parent's house the next week. This may work by the parent living out of district merely dropping said child or children off at school on their way to work. I, personally, after discussing with fellow students and other children through email and other forms of communication, have tallied up what was the most difficult thing about their parents' divorce. The most difficult thing for the children I surveyed was seeing their parents argue over who had control over the children. The children most often, therefore, thought that they may be the main reason for their parents' divorce, which is a thing most of the leading psychologists and psychiatrists would say is a bad thing. Shared parenting would help to eliminate this through split decision-making. One example may be where the mother has the final say over education and religion, and the father has the final say over medical and extracurricular activities. This gives both parents a sense of power, also allowing them to negotiate and work things out in all areas for the best results of the child. Please ask yourself a simple question. How would you feel if you were suddenly not allowed to make important decisions regarding your child's life? Many people are beginning to go through this every single day. Personally, I think it would be a very difficult task. I give help to people who go through this regularly. For example, the first person I helped was a mother who was dealing with a daughter who was choosing to go live with her father, and she was fighting it. I advised her not to unless the father was truly a bad alcoholic, drug addict, or some other type of person of questionable character. This would allow for her daughter to understand that her mother supports her. It may take a while, but the daughter will come to see her more. I heard from her about a month and a half later, informing me that her and her 14-year-old daughter were having about the best relationship since her and her husband had gotten divorced. Shared parenting would allow both of the parents to make decisions concerning the child, helping to create a healthy and productive environment for the child. By now, you may be wondering as to why I choose to speak to you on this issue. Well, I myself a child of divorce. My parents' divorce was very difficult on both me and my sister. My grades would drop when tension rose. My behavior was greatly affected. Just in general, my whole demeanor. Well, slowly, I'm still getting used to it. I'm afraid for the children who may still have to feel it. When I was 14, I chose to come and live with my father, moving away from my mother's home. I did this mainly because I felt that although both parents caused a lot of tension, I may be able to put up with my father's more or less problems easier. I felt a lot of pressure as if it was a which parent do you love more type of situation. In shared parenting, both parents are active in the child's life. This removes the whole predicament that I personally experienced as a possibility for the future generations of Georgia's youth. Please visit my website, www.billsarena.com, for more information. We have a walk scheduled for February 20th of next year. I would be happy to answer any questions that you may have now or in the future. My contact information is included in the folders that I've provided you with. Now is the time to support shared parenting for Georgia's future generations.
That was marvelous. Well said. Thank you so much. Are there any questions of Mr. Sears? Representative Lindsay.
Just to invite him to come back if this bill gets dropped and we go before the Civil Judiciary Committee. I invite him to come back again.
That's true. Any other questions?
Thank you.
Well done. Thank you so much for coming today. You really did a great job. Kept us on time. You're better than any attorney I've seen here today. Believe me.
Okay.
Anything else? Thank you so much.
Thank you.
Okay. Let's see. Mr. Corbin, you said you could come back. Is that something you want to do, or how do you want to handle this? I know you're from out of town, so.
Mr. Chairman,
Pardon?
are you speaking to me?
Yes.
I plan to be back, and if it helps the committee do its business more efficiently, I can wait to make my remarks whatever time it's convenient for the committee.
Then why don't we just do this? Let's see how we progress, and if you can just hold, and then we'll see what our timing is as we get towards the end. Maybe we can do it then. I don't want to press you. I know you've come a long way to be here today.
The opportunity just to participate in this is a good process.
Okay, thank you. Okay, let's move to Mr. Bill Akins.
Thank you very much, Mr. Chairman. I appreciate the committee giving me this opportunity.
Tell us who you are there, too, Mr. Akins.
And I'm reminded of W.C. Field's comment about not working with children or animals. But here I am. Before I actually get to some of the things that have been addressed so far this morning, I want to touch base on how we get to where those issues arise. It's very nice to build a crash-worthy car. It's even better to avoid the crash in the first place. And back in the summer of 1982, when I was basking in the glow of my domestic relations class in law school, they kept talking about marriage as a contract. And they said it's a contract, just like a contract to build a house, a contract to buy a car, a contract to do anything else. And until recently, at that point, a marriage contract required that somebody be at fault, and that whoever broke the contract was going to pay some consequences. But then this thing called no-fault divorce came in. It probably seemed like a good idea at the time, sexual revolution and all. But what's happened since is that what we have is a situation, a contract, where one party can unilaterally just say, I'm done, I'm out of here. And all too often, they are rewarded financially and otherwise, and they absolutely pay no penalty. And the way it works is that we have got a point now where the children are the prize. Okay? Custody and child support are the two things that go to the winner. Sometimes it's also a means to punish the other side. I'm taking your children away from you for whatever reason. Now, I've heard some people lament the child support guidelines, and as Representative Earhart knows, I've been somewhat involved in this, and I can tell this committee, and I will tell anyone who'd listen, the child support guidelines that go into effect in January are no more complicated than the child support guidelines in any other state in this country. They are very much, in fact, simpler than in a lot of states. And I, for one, am not going to tell Superior Court judges in Georgia that they're too stupid to figure them out when they're basically the same things that are at work in North Carolina, at least in terms of the format. But in terms, and I do agree with the earlier speaker who said that to some degree the guidelines are going to minimize fights over custody. I think custody can also minimize fights over child support, and the way you do that is with a presumption of equal time. However you want to categorize joint custody, legal custody, physical custody, you've got to have a presumption of equal time. If you look at any divorce petition, you will note the petitioner is not one of the children. The respondent is not one of the children. Children don't file for divorce. The law in Georgia should do everything possible to keep the status quo in that household prior to the beginning of the rift, anyway, as close as possible for the sake of the children. Chairman Rice, you went on at length when we opened with all kinds of problems that come from single-family households, lack of involvement of fathers. Unlike some of the speakers, I can tell you, sir, there is a case to be made still that a lot of courts in this state treat fathers as nothing more than sperm donors with checkbooks. The presumption of equal time should be the starting place. Okay. You then go on to, and I'm talking about physical custody for the most part, you do need a parenting plan. That is going to force each party, as has been indicated, to think it through before they get to court. I would also suggest that once a court order, a divorce decree is put in place with issues of custody, visitation, and support put in there, that the law provide that those provisions do not become final for 1 year from the date of the issuance of the decree. That's when the judge signs it. Because what you're going to have then is a situation where you're going to force the parties to live with their parenting plan, to live with the arrangements that they have put in that order for a year, and you're going to have a lot greater judicial economy because, number one, the provisions become permanent by operation of law if no motion's filed. Okay, now, if there's something that comes up where a party needs to change that, you don't have to wait 2 years. You don't have to file a separate action. You can come back in by motion and deal with it in the underlying case before you get too far down the road. So I just in brainstorming with you, I think that would be helpful. A couple things to touch on. Age of election. True enough, there is going to be there are going to be situations where there is bribery, and I would tend to endorse not getting rid of the age of election, but I think the rebuttable presumption is a good idea. I think that with the age of election, you should have a guardian ad litem appointed as a matter of routine to check out just such issues and make sure there's no undue coercion going on. In terms of attorney's fees, I would suggest that an awful lot of people file decrees for divorce, child custody, what have you, with the presumption that the other side's going to wind up paying their attorney's fees. Any divorce practitioner will tell you that the common wisdom is he who files gets the child, okay, which also means the child support, which often means alimony, and which often means attorney's fees. Okay, the American rule, and I've done some research on this, having been forced to pay some attorney's fees in my day, for no other reason than I, sought custody of my daughter. The American rule is that each side pays their own fees. Okay, that's the American rule, and I can provide you a site for that. I can provide you a handful of cases that say such things here in Georgia, that there is nothing wrong with vigorously contesting a case. Okay, now, if you have a situation, as some of these folks have mentioned, and I'm primarily a criminal prosecutor, so I understand the problem with domestic violence cases being used for leverage in domestic cases, you also have, in addition to attorney's fees, you also have additional civil remedies for defamation. You have civil remedies for malicious prosecution, where you can get a lot more than just attorney's fees. So these things are also alternatives. The final thing I would urge upon this committee and upon the legislature in general is please, for God's sake, avoid legislation by anecdote. And you've, thrown the wet towel on anecdotes for this morning. That's probably not a bad idea. But nevertheless, that kind of thing happens. We heard Judge Ray come up here. With all due respect, I've worked in Gwinnett County. He's a wonderful guy. But he mentions one case where a kid bounced back and forth. Okay? So you, sitting here on the committee, you have one case in your mind. How many hundreds of cases has he actually dealt with in his courtroom where that didn't happen? I urge you to use the resources of the university system of the state of Georgia. There are academics out there just waiting for the right thing to study and the right grant to do it with. Okay? But these people can help you. Okay? And they can help you make decisions that are appropriate for and will do the most good for the most people. And I'll give you an example, because some of you are of my vintage.
We're gonna have to move along here.
This is the last thing I'm giving you. Years ago, back in the 70s, you may recall that there was a big study that came out of Harvard. Female professor publishes a paper saying women who get divorced suffer a 75% reduction in their standard of living. Made the press, big deal, all over the place. The one thing you did not hear was the fact that there had been a whole lot of other people studying that very issue, and they were all scratching their heads because their figures were indicating, and this is 30-odd years ago, somewhere around 25%. So they start saying, well, can we see your underlying data? And no, you can't. Finally, after about 10 years, somebody said, well, Professor, isn't it possible that what you did was switch your arithmetic around, and instead of losing 75% of their standard of living, they maintained 75%? Well, guess what? She admitted, yes, she was wrong. There had been a math error made. Okay? So, and now the latest studies indicate that in divorces, both parties tend to lose somewhere between 5 and 10%. Both parties' standard of living goes down. So, in any event, please try to avoid legislation by anecdote. Thank you very much for your time. I presume you have no questions because it's getting late. I've been here since 8:30 this morning. So I tried to beat the traffic and did so with a vengeance.
Yeah, there's a question down there from Mr. Butler.
Yes, sir.
It seems like we've all got different opinions on the idea of letting a 14-year-old make a decision about where they live. And that's been kind of bouncing back and forth.
Sure.
I'm just wondering, let's say that we did decide to keep keep that intact. How do you think, just like a lot of other situations, that if we put a minimum time when a child that age or a little bit older would change their mind and go back, say like, okay, if you make this decision, we can't revisit this for 12 months, 16 months. So that way they cannot be put in a position where, okay, 3 months later, because I'm not getting what I want over here, I want to jump back over.
Well, I think your better practice would be to make it a rebuttable presumption, and frankly, I think 12 is appropriate, because at 12, most of the time, the hormones are yet to rage. Okay? But keep it a rebuttable presumption, but the problem I have with putting any kind of limitation on when you can come back is that circumstances may change radically within that period of time, and it's nobody's fault. Somebody may get laid off work. Somebody may be in a traffic accident. And you've also got a constitutional issue with access to the courts. You see, so saying you can't revisit anything for 2 years or 18 months, I just think is bad policy.
But now, correct me if I'm wrong. Now, once you have a custody case decided on, like you get divorced and then the court say that you can't come back and make an adjustment unless there's a...
That's what they say, and I disagree with that.
Okay.
But now, the possible solution is what I suggested earlier. Make those parts of the decree, child custody, visitation, and child support, make those temporary for a period of 1 year, so that you get some sense, and the parties get a sense of what they're really living with, and then that can be fine-tuned by motion within that 1 year period. And that might work on the election as well.
Any other questions of Mr. Atkins? Thank you for coming down here.
Thank you very much.
Just had one question that dealt with, let me think what the question was here. I'm using my own time here, so hold on for a second. It'll come to me. I'll get back to you. I have your address.
Fair enough.
I'll give you a call.
Thank you, sir. Thank you very much.
Thank you. All right. If anybody sees me looking down at my badge to figure out what my name is, then you'll know we're really in trouble here. Stop that.
I didn't say that.
I was just so interested in what Representative Butler had to say that I just, my full attention went to you, Representative Butler. You took my mind right off everything else. Okay. Let's move along. Mr. Pitts from Martinez, Georgia. Or is that Martinez? Is it Martinez or Martinez? Martinez. Okay. Okay.
Named after a Cuban explorer named Martinez, but here in Georgia we take liberties with Hispanic words, apparently. Good morning.
Good morning.
My name is Terry Pitts. I'm here from Augusta, or Martinez to be more specific. I'm not an attorney. I'm not an eloquent speaker. I'm a high school science teacher, and I am as nervous as can be. However, I am a vigorous proponent of shared parenting. Years ago, when my divorce started, my attorney said, never going to happen, laws will never change. Unlike MAD, Mothers Against Drunk Driving, where drunk driving is an issue forever, parents' issues go away when the children turn 18. Perhaps it's time that people today in Georgia step up, fix the problem, so my own son, my own daughter won't have these issues in the future. I have an analogy that I like to use. If a man is a truck driver and he's only home on alternate weekends, we say, oh, poor children, they need their father. And everybody understands that. All of a sudden somebody files for divorce and we call that Schedule A. And everyone says, be glad you got what you did. There's some hypocrisy there. In Texas, the non-custodial parent, by checking a box on a form, gets what's known as expanded standard visitation, 146 days per year. State law, all he has to do is request it. In Massachusetts last year, 85% of the citizens voted in favor of a resolution supporting presumption of shared parenting. People come up with all sorts of hand-wringing excuses. Oh, it will never work. Where do you start? They have to cooperate. My argument there, or my rebuttal is, think about this, Mr. Chairman. If I said I have $1 million, and if we cooperate, you get half, am I going to cooperate? I don't believe so, because I'd keep the whole pie. As Mr. Atkins said earlier, There's a tremendous financial prize associated with this. But people forget when the parents walked into the courtroom, they had joint physical, joint legal, shared custody. They had what the children want and what the children need. Nobody gets custody in the courtroom, ladies and gentlemen. Somebody walks out having lost custody of their children. We don't get it, we lose it. Why do we have custody battles? I can't stand that term, but why do we have them? Because, as Mr. Edlin was saying earlier, we have trial court, trial judges, trial lawyers. There's no winner and loser. There's no criminal. There's no guilt. There are two people who choose not to live together. Why do we have to have a winner and a loser? Let's start with the position that in the 21st century, men and women are equal. Is that so wrong? Is that so crazy? Men beat up women. Women beat up men. More women kill their children than men kill their children or wives. The statistics show that children are safer with fathers. They die less. They do better in school, off drugs, teen pregnancies. The federal government spent $360 million last year on, quote, fathership initiatives to keep fathers in the children's lives. With the stroke of a pen, the legislature and the governor can do that for free. And think how much money we would save. Keeping the children's parents in their lives is a wonderful thing for them. My own personal experience is very unusual. I am a custodial parent. My former wife and I have, I guess it doesn't fit the definition of shared custody, but it fits the look. We have a split custody arrangement. We each have custody of one child, and they follow essentially equal schedules. We went from a very bitter and acrimonious relationship where there was no cooperation whatsoever. If the kids wanted to do something with me, never allowed. Could we make a little change? Never allowed. It was amazing what happened when custody of one child shifted, and now there was no gigantic inequity of power and control. Since then, I got custody of my son due to basically emotional abuse issues. And since then, there's been a significant increase in the amount of cooperation and flexibility, willingness to talk and email about problems. My ex has had me come over to her house when there were problems with the children or meet somewhere to discuss and cooperate. So why do we have to decide who's better? If neither parent is bad enough for DFACS to come in and yank the parent out of the house, why does one have to be better than the other? George Patton one time said, the enemy of the perfect is the enemy of the good. People look for perfect when good enough is okay. Your yard doesn't have to be perfect. Your car doesn't have to be perfect. So why do our parenting skills have to be perfect if we're divorced, but not if we're married? The American Psychology Association says in study after study after study that that the more time the children spend with both parents, the better off they are. And as that approaches roughly 50-50, those children are as well adjusted as children in two-parent households. And I challenge you, who knows more about parenting and children? Somebody with JD after his name? No offense. Or many, many, many child psychologists working and studying for years. I would submit to you that the psychologists know a lot more about children than they do about the law, and our court system knows much more about the law than it does about children. Let's start with the premise of 50-50, as 29 states do now. Start that from day one. Make the judge put a reason to deviate in writing. One of the opposing arguments is, I have to be not sarcastic here, that takes away judicial discretion. If maternal custody is the outcome in 92% of the cases, there's no judicial discretion. So let's make it 50-50, and if we need judicial discretion, the judge writes down his or her reason why. That is true judicial discretion, letting somebody make a choice in compliance with the law. This is the 21st century. This is Georgia. We need to move our state forward. We need to truly do what's in the best interest of our children, and pushing either parent out of their lives is not appropriate. I've heard attorney after attorney today talking about minutia and statistical outliers. Who's going to pay that attorney? Do we need a third attorney looking after the children? That's a bunch of horse droppings, let me say. You get rid of the problem by getting rid of the argument. If both people go in know it's 50-50, you're not trying to take a parent's children away from him or her. So why do we fight? I'm not going to let somebody take my children away, whether that's another person, a stranger, a kidnapper. My children are important to me, just as they are to virtually every parent in Georgia, male or female. That's why they fight, because they love their children. They're not fighting because they hate somebody. They're not fighting because they can't afford the $3,000 retainer they paid. They're not fighting because they can't afford the $3,000 guardian ad litem fee. They're fighting because their children are being taken away, and they didn't divorce their children. And that concludes my presentation, and I'll be glad to answer questions if you
Thank you, Mr. Pitts. Are there questions of Mr. Pitts? Mr. Pitts, I really appreciate you taking time from, is this a day?
I'm a school teacher. I get 3 days off a year, and this is one of them. It's something that I believe is worthwhile. It means actually losing a vacation day with my kids, but I'm here because I've discovered there are some things that I'm passionate about, and this is one of them.
No, we appreciate you taking that time and coming down and
Thank you,
voicing
sir.
your concerns. Okay, Mr. Zachary Holliday from Roswell.
I've got a little show and tell if I can drop these off for you all to show you the reason I'm here.
Oh, okay.
Good afternoon, Mr. Chairman. Thank you for your time, and for members of the committee, I appreciate the opportunity to talk to you today about my personal situation, not to go into anecdotal information too much, but just to give you a little background on why I'm here today and my vested interest in forwarding shared parenting in the state of Georgia. I moved to Georgia about 10 years ago. First of all, Zachary Holliday. I live in Roswell, 43 years old. I work for the Hewlett-Packard Company, and I've been a tax-paying citizen of the state of Georgia in Roswell for about 10 years. My children, as you can see there, are 9, 10, and 12, so they're at very fun ages right now. Currently, I am a baseball coach at Roswell Rec. I coach 2 teams, my youngest daughter's team and my son's team, and I'm also a Webelos Den leader for PAC 1486 in Roswell. When I moved to Georgia about 10 years ago, I had tremendous expectations of delivering a very fine upbringing for my children. Little did I know that I was going to be in a system that is very uncaring towards fathers, as it is today. I want to talk about my firsthand experience and the reason why I think that this is a noble cause, because I have my kids almost 50% of the time. I can tell you that my involvement has been a critical success factor in my kids' lives. First, a little history. I've been actively involved since day one with all 3 of my kids. Interesting to note that only divorced fathers are suspect in this area. I've been there for every milestone since birth, the first tooth, first steps, first words, all the other stuff, the diaper changes, the midnight feedings, the doctor visits, the baths, you name it. I'm no less a parent than their mother, and I have earned the title of dad and father. About my children, my oldest is in 7th grade in Talented and Gifting and running for Student Council Vice President in Roswell. She's a Girl Scout, cheers for the Roswell Junior Hornets, and does gymnastics and wants to become a doctor. My son is also an excellent student and patrol at his school. He's a Webelos Scout and will earn his Arrow of Light and cross over into Boy Scouts in April of 2007. He plays baseball at the Roswell Rec and has a league and division championship under his belt by the age of 10. I played baseball for 15 years. I never had a championship. He wants to attend West Point or the Naval Academy. My youngest daughter is also very outgoing and academically gifted. At 9 years old, she swims competitively, plays baseball at Roswell Rec, and does gymnastics and Brownie Scouts. I'm very, very proud of my children. They are tremendous young adults. None of this would be possible without my active involvement. Not just financial support, but time and talent. Translated, money does not equal parenting. As you know, the default position today in Georgia is more than 90% of the orders, the mother gets physical custody. Women's groups, some attorneys and judges will tell you that this is best for children. That may be easiest for them, but not the best for children. All too often, this agreement turns parents into litigants fighting over issues for years. This marginalizes fathers and teaches children of divorce that dads are not vital to the family. How can this be good for children? This process cannot be about what's easiest for attorneys and judges. It has to be about what's best for Georgia's children. Children need their fathers, and each situation needs to be looked at individually within a framework that guides total strangers, judges, and attorneys to the best possible outcome for the children, not what is easiest and most profitable. I submit that when you take the money and power out of power over a former spouse out of the equation, parents are more focused on being parents than litigants. I know that's bad for the system, but that's what needs to be done. Also, joint legal custody is a myth. I know that we've covered that, but I'm living proof. I have joint legal custody and still have problems with the school not allowing me to pick up my children from school in the afternoon without a note every single day and permission from their mother. Organizations like Girl Scouts that will not mandate communication between their leaders and me. All I'm interested in knowing is about the activities that my daughter's involved in. Churches that will not allow divorced fathers to look at Sunday school records or other records that they have interest in. The presumption of joint custody should be the norm in Georgia. At a minimum, a law should be passed to make all school and church records available to divorced parents. Either parent should be allowed to pick up their children from school, and school data systems should be modified to include addresses of both parents for all important correspondence. Unfortunately, we live in a society that vilifies divorced fathers, an archaic, dated, sexist system that drives apart families because it's focused on money and power. Average citizens are counting on leaders like yourselves to overcome prejudice, change policy, and give divorced fathers a real opportunity to be a part of their children's lives. Thank you.
Thank you. Appreciate you joining us here in Georgia from wherever you came from originally.
Orlando, Florida.
Orlando, Florida. Any questions for Mr. Holliday? Thank you, Mr. Holliday. You have a beautiful set of children there. There you go. Okay, great.
I get passionate when I talk about kids.
I understand that. I understand that. Okay, Mr. Darrell LaCroix. Let's hear from you.
Thank you. I want to thank each of you for allowing me to be here on this important subject. I'm going to try to, I got the admonition about anecdotal things, and I'm going to try to abide by that. And I thought I'd be most useful if I gave you the ideas that I have for a proposed statute.
That's good.
I think we need the presumption of equal custody, and I think we need the burden on the parent objecting to it to have good reasons why not. Divorce is a major change to the intact family household. So I would like to see you make sure that the presumption stays in effect for at least 6 months. Now, my concern is not to have everybody run to the courthouse to fight this presumption, so let's tell them that they've got to live with it for 6 months. And in the contested, I look at the seatbelt law. Most people obey the law because that's what the law is. They wear them whether it's enforced or not. That's the law. I expect most parents are going to say, that's the new law. We need to work out a parenting plan, figure it out, and they're going to follow it. There are going to be some that are going to contest it, but I would say that the person that contests the presumption within 6 months, if they're not able to show good reason like potential harm to the children, that they be responsible for the other side's attorney's fees and expenses for going through that exercise. My 6-month thing is because the intact family is a different animal from the separate households. What we see in custody cases is people coming in and saying, well, Dad never did that during the historical marriage. Well, that's not what we're talking about now. We're talking about 2 separate households. If we give them a 6-month time period to live with it, the judges will have an opportunity to take a look at how they worked it out. How did they perform? In every contested case, I would have a guardian ad litem appointed. That guardian ad litem will have a number 1 priority of their concern will be the safety of the children. If somebody's saying, oh, he's terrible, the kid's going to be in harm's way. That should be their first concern. Their second concern should be the cooperation that parent has with the other parent concerning these children. After 6 months, the court can hear the case, and that parent who has not cooperated or has cooperated the least will be at risk for losing their 50% physical custody statute. So absent a safety concern, a valid safety concern, the attorney's job will be to work with the client to customize an equal parenting schedule which best fits the parents' work schedules and the children's school and activity schedules. Now, I'm saying a clear history of child abuse, an addiction problem, alcoholism, these are good, understandable reasons why not. The psychologist testified in one of my cases that the alternate weekends for Dad is a legal construct which has nothing to do with what's best for the child. This particular psychologist favored exchanging the children on Sunday afternoons, every Sunday afternoon. Another psychologist advised that when you ask a child to draw his mother's home, his father's home, the well-adjusted child of divorce draws 2 houses with a bridge connecting them. In 1993, over 10 years ago, the Honorable Dorothy Beasley, in the case of Henry ARB, which doesn't get nearly the attention anymore that it used to, but I think it deserves it, she summarized a progression of legislation which was intended to move us in this direction. She first referenced the preamble of the '83 Constitution that having the express purpose to promote the interest and happiness of the citizen and the family. She referenced the joint custody statute as an implementation statute. Oh, I wish it were. But anyway, she said this would allow the option of joint custody. They can't legislate, but they can express strong opinions. Under such arrangements, both parents are given equal rights and responsibilities for major decisions concerning the child, or equal opportunity to be with and nurture the child, or both. The legislative intent is to afford greater equality between the parents so that the best interest can be served. It is correlated with the equal duty of the parents generally to support the child. Both these statutes evidence a policy favoring equally shared parenting obligations and opportunities, which places the children first in the constellation of individual interests and desires. She then noted the amendment that said there shall be no prima facie right to the custody of the children and the mother or the father. The legislature has tried to move us in that direction. Then she noted the statute that says it's the express policy of the state to encourage that a minor child has continuing contact with parents and grandparents who've shown the ability to act in the best interest of the child. So the legislature has tried, by giving judges options, by encouraging them, by using the words. Hasn't happened yet, though. When she concluded, and I want you to hear this because it talks about the child's right, and I don't hear anybody saying that. It is thus evident that the stated legislative policy abandons traditional biases and favors shared parenting rights and responsibilities, where both parents have demonstrated equal ability to effectively care for and nurture the child, as here, that case. It is in the child's best interest that a custody war be fashioned which will best encourage continuing and roughly equal contact with both parents, given the practicalities involved. Joint physical custody should not be automatically rejected simply because the parents live in places distant from each other. And here's where she gets to it. The child who is not an official party to the lawsuit but whose well-being is in the eye of the controversy has a right to shared parenting when both are equally suited to provide it. Inherent in the express policy is a recognition of the child's right to be guided and nurtured by both parents, the right to have major decisions made by the application of both parents' wisdom, judgment, and experience. The child does not forfeit these rights when the parents divorce. whether a parent forfeits his or her portion of the relationship or any part of it, or is incapable of performance, must be determined by the fact finder. So what's keeping us here? What's the problem? I suspect there's several reasons, but one is that we're creatures of habit. Our judges, our public, and lawyers are in the habit of assuming that mom's the best place for the kids. It's the exceptional case where dad gets the custody. Mr. Schiffman and Mr. Edlin, I agreed with a lot that each of them said, but I think they came to testify on the wrong day. They should have been here on the opposing day. And I'm not saying it's their fault. I would like to suggest that they have a skewed view of their clients. Their clients are limited to those people who can afford them, those people who can afford their law firm. And you folks have got to make laws for the vast majority of people that cannot afford to have what they do to get a dad custody. We need that presumption. We're not going to take away the judge's discretion. We're going to give the judge the opportunity to review the efforts of these parents to work out a plan, to review their efforts to exchange a child and make it work. And you're going to give the parents a chance to possibly even be better parents. Now, some parents are going to need more, going to need some training classes even over and above the class for divorcing parents. And that may be appropriate that they do that. I mean, I know it's not on your agenda, but a pet peeve of mine is I wish that there was a required parenting course in high schools. I mean, it seems like most of those kids are going to be parents one day. Why shouldn't they have some basic information? Why shouldn't we require that? And where can that come from except from the legislature? Give the court the benefit of reviewing the efforts of the parents before making either parent a visitor in the child's life. I want to quickly just look at the...
Just before, we're going to have to move along.
Okay. The Family Violence Act, it's too easy to do it ex parte, and there needs to be a mechanism to expunge something like aggravated stalking on a man who inadvertently talked to his wife about the kids in the no contact orders. The election of the children, make it hard for them to make the second election. Leave it in there that they can make the election. Make it where and appoint a guardian ad litem for every case of an election. And absent compelling circumstances, that child's got to live with it, and make that guardian ad litem make that clear to the child. We need strict rules for the guardian ad litems. You need to note that they're also not elected just like senior judges, but most judges follow the recommendations of the guardian ad litem. So they need clear guidelines and training. And I think that covers my main points, if there are any questions.
Questions for Mr. LaQuarrie? Mr. Lindsay? Sure.
We've heard a lot about guardian ad litems, and I too am an advocate for that particular system. Actually, I passed the SHIELD law with respect to liability for guardians 2 years ago here. Are you aware of any other states that set guidelines and training for their guardians? I think this committee could benefit by that.
I think you could too, but I really have no knowledge of the other states' use of guardians. But just the fact that the judge can't go visit the home, can't go talk to the teacher, it serves a very useful purpose, but it's confusing as to what their authority is and what they're supposed to do, how they act in court, whether they're subject to cross-examination. Different judges make up their own rules for those things. So it needs to be addressed.
Yes, Mr. Lindsay?
Perhaps we should get someone from Atlanta Volunteer Lawyers Foundation in here to talk, because they do have a training program. You can only become a guardian in Fulton County if you go through the AVLF program, and they have a training program, and they have...
If we've heard anything today, there needs to be some standards, some outline, some template within which to work. I think if we've heard anything that everybody's agreed on, even those that may not agree, is there needs to be some direction in some sense. I'd like to hear that. As staff will look for other states' guardian statutes, I'd be appreciative also.
Mr. LaCroix, one other question I have. When you mentioned expungement, are you talking about the criminal charges, effectively? If they
The fact that they have this no contact little box to check, and my client was talking to his children on the telephone, and a subject came up that he felt that he should talk to his wife about, and he says, "Can I talk to your mom?" And he did that, and that's in violation of the court order, and that is by definition aggravated stalking. Now he went on a trip to Alaska and Canada, and they wouldn't let him off the boat or something because he has a history of aggravated stalking for speaking to his wife about his children. And that's just too easy, these forms that they use in family violence. It's just boom and it's done. I've heard of an airline pilot. It greatly affected his job. Having that sort of thing it's draconian, and there needs to be either changed or some easy remedy or a procedure to cure that.
Okay. That's all the questions for Mr. LaCroix. We thank you for coming today. If you have stuff written material you'd like to leave, you
I would.
give a copy to Mr. Williams here. There's one other, we just have a few minutes left, but there's another group that came, not group, there's another person. A person is not a group. Let me clarify that. I don't remember your name. If you could just tell me your name again from North Carolina today.
Bill Wood.
Bill?
Bill, yeah.
And your last name is?
Wood.
Wood. That figures. Okay. Short, just like mine. Easy to remember. Come on up, and we'll entertain your comments for a few minutes since you've come so far today.
Mr. Chairman, I invited Will Rooks to come if there was any time. His father's an attorney, and he's a product of 50-50.
I don't know if we're going to be able to get to that, Mr. LaCroix, but there are opportunities to come back if we want to. It's possible.
Thank you very much, Mr. Chairman, and thank you for allowing me to come and speak to you about some of the issues involved in this important consideration that you are looking into at this point in time. Before I get started on some of the...
About 5 minutes now, Mr.
Okay. Before I get started, I just wanted to say very quickly, one of the things that I had relayed to you is that I actually am a custodial parent. I got custody initially of my daughter when she was 8 years old, who's here today with me. And I am, in spite of getting custody, I am 100% in favor of shared parenting and a presumption starting off with equal custody. And there's a lot of reasons for that. And I don't have time today to go into all the reasons, but just to give you a quick 60-second overview of some of the things that I went through in my personal experience. I was raised with, like many people are, with these civics notions of the judiciary and fairness and equity and the law is supposed to do certain things. Well, I got a rude awakening when I went into family courts in North Carolina.
Were you per se?
Not initially. Initially, I was represented by an attorney, and I was up against my ex's attorney. She had two guardian ad litem attorneys who had clearly sided with her, two volunteers from the guardian ad litem program that they have there. And I want to say up front, their guardian ad litem program is actually a pretty good program if you wanted to look at one to emulate. And they actually had made some changes as a result directly of my case, too. Also a PhD psychologist and a master's degree social worker who filed a false forensic custody evaluation. After a 3-day bench trial, initially I went in, fired my attorney, represented myself against everyone else arrayed with my now ex-wife for custody of my daughter to go to my ex-wife. After a 3-day bench trial, I won. Now, I had a very conscientious jurist, a judge who was a very fair judge. He was a chief district court judge. After my case, there were several local rules implemented and several things changed too. But what I'm here to say is part of what got me on this crusade some almost 8 years ago now is what I experienced, nobody, I don't care who you are, should ever have to go through that again. And there are no words strong enough that can relate to anybody just how broken the system is. And it's not just in North Carolina, it's all over the country. I have gotten involved with a number of fathers groups, and some of them are a little radical, and some of them not so radical, all over the country, and I cannot believe some of the horror stories that are out there. And they're not the exception, they're the norm. And that's disturbing to me. One of the things that I did during these proceedings, I don't want to spend a lot of time on any more history here, but over the years I've studied literally, and I've worked with Stan Thorne, who's here, probably close to 10,000 more or less hours in the law, social studies issues and all. And one of the things that I have discovered is there's a lot of very common sense things that can be done to correct the laws that are very reasonable. One of the things that we do in North Carolina, which works very well, is there's a mandatory requirement on all judicial orders for findings of fact and conclusions of law. I don't know that you have that here. And I think that that would go a long way towards helping to alleviate some of these things, is just simply mandating that a judge has to make a finding of fact and conclusions of law. And for the shared parenting issues, I think that all of these things, I think that it's more than reasonable to ask for a rebuttable presumption to start off with the idea of equality, and a judge simply notes findings of fact and conclusions of law as to why the shared parenting, the equality won't work. On the domestic violence issue, findings of fact, conclusions of law, not just a check mark on a box as to why. I experienced false allegations of domestic violence, which, unusual in my case, I actually could prove. One of the things that's a requirement in North Carolina is that you have to give very specific information about the claim. Well, my ex happened to, because I travel a lot for my job, happened to give a date and time when I was 1,200 miles away that the event took place. After having filed 2 other claims that were totally out there, that were rejected by the first 2 magistrates, she finally got a 3rd one that had the specific dates and times when I had receipts to show I was in another state. So that didn't work too well. And then also I had false allegations of child abuse and child sexual abuse brought against me. Interestingly, in my case, most judges will not deal with that, and I'm automatically branded right off the bat. But I was smart enough and had been warned, so I recorded conversations, and she admitted over the phone in a recorded conversation in North Carolina that they were false claims. She knew they were false, and she'd commit perjury in court. It's kind of hard to win a case like that, even though all of the other individuals on my ex-wife's side had gone ahead and said they were going to go ahead and side with her to get custody. So there are a lot of other things that can be done. One of the things that I was strongly encouraged to hear, and I have written, which has been accepted by the by the federal courts on appeals against some of the child custody laws in other states, amicus briefs, and I've researched the issue very carefully. I've offered congressional testimony to the U.S. House of Representatives, the Ways and Means Committee, on issues related to fatherlessness and some of the information that's often cited and reported and studied. I have several submissions there that have hundreds of references. And like I said, I've spent many thousands of hours. One of the things that can be done, too, is to, starting off with this presumption of joint custody or shared parenting, also reduces the divorce rate. There was a study that was done several years ago, 5 or 6 years ago, called These Boots Are Made for Walking, the largest study of its kind. 46,000 divorce cases were evaluated, and I can give you a copy of it if you would like, that where they were looking at the few states that still had fault-based grounds on the books. They evaluated several options, including domestic violence, infidelity, and a number of other things. And the conclusion that they came to is the one thing that drove divorce behavior over and above everything else was the expectation of child custody. By far and away, after accounting for every other variable, that was the conclusion that they arrived at. And so one of the obvious outcomes is, if you start off with a presumption of joint custody, or if you start off with a presumption of equality, then what happens is you reduce some of these frivolous divorces that are because, Joe and Susie just aren't getting along and they're upset and they're frustrated. My wife and I get upset at each other at times. We all have days, and looking back in hindsight, after such a stupid thing is followed through on sometime, I'm sure that there are a lot of people that have regrets. This is one way to help to kind of keep things sane at a time when people's emotions are charged, when they're frustrated, when they're upset, when they're not thinking, frankly, rationally. I was encouraged to hear that the head of the bar here was asking specifically for best interests to be defined. Obviously, as anybody knows about this issue, that's probably one of the biggest gaping holes in the system anywhere you go. And it would move Georgia from, to be very candid here, and I don't mean to be insulting, from somewhat behind the times with many states to on the leading edge of some things to actually have best interest standards defined. And I would encourage you, if you look at that issue and you define some of those things, I would encourage you also to look at leaving some latitude in the definition of those best interest standards and asking possibly the judiciary to come back and report maybe on an annual basis any particular cases that they feel are very important in helping to clarify those things, or any suggestions they have possibly that would help to bring some more rationale to the best interest standard and what factors would constitute best interests, to create a process where there's constant feedback, input, and course corrections where necessary. Again, one of the things that I was a little surprised that the judge noted was earlier, the first individual who testified, was about the clear and convincing evidence standard. For a layman's understanding of that, to put it very simply, is that it has to be based on some sort of either corroborated or objective proof. He said, she said is not clear and convincing evidence. That's obviously the preponderance standard. And I don't think that it's unreasonable to ask for clear and convincing evidence on several of these things, whether it comes to domestic violence claims, whether it comes to making the child custody determinations, or overcoming a rebuttable presumption. On domestic violence claims, since I have been the recipient of false allegations myself, I think that there should be two tracks, because the 10-day hearing is not sufficient time to really prepare for an adequate defense. I think there should be two tracks. If there's undisputed claims, obviously the situation needs to be dealt with. If there is an allegation of domestic violence and it's undisputed, you know what? That needs to be dealt with harshly. But if there is a dispute, then normal rules of discovery, normal processes and procedures that would fit normal due process requirements have got to be brought in somewhere. And whether that means holding off on or having a second hearing after the initial 10-day determination, that, you know, we're going to have another hearing 30 days, 45 days, 60 days from now to deal with the disputed domestic violence claims, I think that makes sense, because then you are affording them appropriate constitutional protections while taking care of a potentially, possibly violent situation in the short term. Now, that's just my initial reaction based on some of the things that I heard. Shared parenting, I believe, based on the research that I have, and then I'll wrap up here, would reduce divorce if you start off with a mandatory presumption of at least equality. And everybody, no matter what anybody says, must be considered equal before the bar of justice when you appear in a courtroom. To say otherwise is to completely misunderstand what the American system is all about. I think it'll reduce social costs. Anytime that you can begin to move towards a situation where children are being parented by both parents, you have a situation where some of the statistics related to fatherlessness, some of those things are dealt with, and obviously the social costs related to the drug use, the alcohol abuse, and the crime, and the involvement with gangs, and the teen pregnancy. As both parents are involved, some of those things are reduced. Obviously, the state would have less expenses related to graffiti cleanup, the gangs. You'd have less expenses related to some of the social programs related to drug abuse and drug addiction. You'd have a whole lot less, hopefully, in the end, a whole lot less jails having to be built. And one of the things that I didn't hear mentioned today that I'm kind of surprised about is there are several studies that even the U.S. government recommends that show where there are both parents involved in a child's life, that child support compliance rates are much higher. And so from that standpoint, there are many, many benefits to considering some sort of a shared parenting situation. Lastly, one of the things that I think is important is if a parent agrees, if two parents agree on a custody situation, then I don't think that a judge should be given unilateral arbitrary authority to just go ahead and throw that out, period. I think there should be, again, a rebuttable presumption to take care of those exceptions in the situation where somebody is potentially engaging in abusive practices. But that I think that the court should be mandated that they have the burden to overcome by some findings of fact and conclusions of law as to why that shared parenting agreement wouldn't work. And one of the reasons that I say that is initially my ex and I had reached one of those agreements. And my judge didn't throw it out, but all of the other parties that got involved pushed for it to be. And there was no abuse involved. We both thought that it was a great way to work things out, and there was not going to be any child support changing hands, which we were both fine with. And we both were going to move on our ways, and we were actually cooperating during this process. The divorce and the post-divorce situation became very acrimonious when the other individuals got involved and insisted that she can't accept that and that's not the way things are done. And we went ahead and moved forward. And it was pretty nasty. After several years, we're just now starting to get along again. But anyway, I'll wrap with that. I would like to, with your permission, submit you some additional study information, including the These Boots Are Made for Walking study and the APA. There's a couple of psychologists that have done what they call a meta-analytic study, where they evaluate basically most all of the data that they have available in all of the social studies and looked at the shared parenting issue, and they are in agreement that this is by far probably one of the best solutions for children in their best interests.
Mr. Wood, we thank you for coming today. Are there any questions, Mr. Wood? We really appreciate you coming down from North Carolina today, and your daughter, too, for joining you. We are going to adjourn at this point in time. We will reconvene at 10 o'clock Tuesday morning of next week, and then on the 26th, we will conclude this. I thank you all for coming today and for your testimony. You've helped us a lot.